everyone. We will be starting with an invocation, followed immediately by the national anthem and the IBP march.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم
In the name of Allah, the entirely merciful, the especially merciful.
الحمد لله رب العالمين
All praise is due to Allah, Lord of the worlds.
الرحمن الرحيم
The entirely merciful, the especially merciful.
مالك يوم الدين
Sovereign of the day of recompense.
إياك نعبد وإياك نستعين
It is you we worship and you we ask for help.
اهدنا الصراط المستقيم
Guide us to the straight path.
صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين
The path of those upon whom you have bestowed favor, not of those who have evoked your anger or of those who are astray.
Just having technical difficulties. While we're connecting, please kindly hold on. Thank you.
bawat mo'y tagumpay na nanginginig. Ang bituin at araw niya kailan pa may di maniginig. Lupa ng araw ng buwan at ipagsinta, buhay ay langit sa piling mo. Aming ligaya naman may mga api, ang mamatay ng dahil sa'yo. IBP, the lawyers of the land, our noble nations unite us. IBP, we dedicate our lives, justice and fairness to triumph. Rule of law, our guiding light, for truth and freedom we will fight. As a people build their destiny, we will find our place in history. Serve the country and the IBP. Integrated part of the Philippines. Sentinel of law and democracy. Marching on in unity. Mabuhay! IBP, the lawyers of the land. Our noble nations unite us. IBP, we dedicate our lives, justice and fairness to triumph. Rule of law, our guiding light, for truth and freedom we will fight. As our people build their destiny, we will find our place in history. Serve the country and the IBP.
Good afternoon again, everyone. I'm Jamie Banyes, the IBP Director for Chapter Affairs. Please join me as we explore the world of the Sharia and gain a much better understanding of the nuances of the Muslim laws and how they can apply in our lives. This is actually the first among what will be a series of webinars on the Sharia, all of these being designed to better our understanding of the laws, whether as members of the legal profession or of society in general. So I'm happy to announce that this is in partnership with the Sharia Lawyers Council of the Philippines, the Bangsamoro Sharia Lawyers League of the Philippines, Inc., the Integrated Shari'ah Bar of the Philippines, Inc., the Association of Lady Sharia Counselors at Law of the Philippines, Inc., and the Philippine Sharia Lawyers, Inc. Before we start, please be reminded of the following house rules. Please rename your Zoom display name to reflect your title or your name appropriately. Always be aware of your surroundings. Make sure that your background is appropriate for the event and that you have the proper lighting, and also avoid external noises such as TV and radio background noise. Please set your microphone on mute as the default setting and mute your microphone if you're not speaking to ensure that all participants will hear the person speaking. Unmute only when advised to. As always, please be respectful of all the speakers and moderators at all times. And should you have any questions, and we'll have an open forum later, please feel free to send them through our Zoom chat box. Now let's get the ball rolling. To give the opening remarks coming in live from Malaybalay, Bukidnon, we'd like to welcome our IBP National President and Chairman of the 25th Board of Governors of the IBP, Attorney Bert M. Estrada. Press Bert.
Yes, good afternoon everyone. Magandang hapon. Assalamualaikum. Mayong hapon sa atong tanan. Firstly, I'd like to congratulate and thank our National Center for Legal Aid and all our partners, different councils and leagues of the Sharia law, and of course our Chapter Affairs Director for this webinar. This is very timely that we are having this webinar, as it is one of the thrust also of our Supreme Court. No, early on in when we took office and assumed as the 25th Board of Governors, one of the challenges brought forth to me, especially being a Mindanaoan myself, was to find a way to implement what was written before in some bar matters, wherein the court has declared the Sharia lawyers as special members of the integrated bar of the Philippines. I am happy to tell you all that during our conversations with the honorable justices and the Chief Justice of the Supreme Court, and especially our very own Justice Timampao, that not only is there going to be a summit for Sharia lawyers within the year, or I think early next year, but that the ultimate goal is that there will be no more distinction between lawyers in the IBP and Sharia lawyers, because as one justice told me, and I believe and I agree with him, that Sharia law is part of the law of the Philippines, and hence Sharia lawyers are also lawyers of the country. And so as brothers and sisters in the law profession, I would much support such endeavor, that one day Sharia lawyers and all the lawyers of the land belong to one integrated bar of the Philippines. And so being in one community, it is very important that we get to know each other and understand each other. And so this webinar will introduce to many of us who do not have any idea about what Sharia law is, and so that we get much better appreciation of this law and work towards a better integration later on, and that all of us can work together in pursuing justice in our country in all laws that are implemented in our great nation. Maraming salamat at magandang hapon sa ating lahat.
Thank you very much, Pressbird. Before we start, I'd like to ask the apologies of the attendees. Apparently, there's some construction going on where I am currently in, so I apologize for any background noise. I know we have our house rules, but as I am the host, we really cannot do anything as of the moment. In the meantime, we'd like to proceed to our first speaker. Our first speaker graduated 16th in the class of 1986 of the University of the Philippines College of Law in Diliman, Quezon City in 1996. He then completed his Sharia training course as sponsored by the Office of the Muslim Affairs at the UPPCID Diliman, Quezon City in 1992. He worked very extensively with the government, starting from the Ministry of Muslim Affairs, as well as working as a confidential attorney in the chambers of the Honorable Justice Ricardo L. Pronove of the Court of Appeals. He also supported our raising awareness in Sharia law by being a lecturer in Islamic revivalism in the National Defense College of Campo Aguinaldo in 1999, Muslims in the Philippines through the PNP intelligence course in 1999 to 2000 in Camp Crame, and as well as Islamic culture, the FSO Cadetship Training Seminar in the DFA in 1999. He's also a prolific columnist and prolific writer, writing for the Diario Uno, as well as having extensive works, both fiction, non-fiction, as also poetry. And then he became the Shari'ah Bar Examiner for the Shari'ah Bar Examinations as conducted by the Supreme Court in 1997, 1999, and 2006, as well in persons and family relations and procedures in Sharia courts. From 1994 to 1998, he served as corporate secretary, and then in 1998 as OIC General Counsel with the rank of Vice President in the National Power Corporation, as well as the Moral Recovery Officer of the same. He also served as assistant professor for the Institute of Islamic Studies in UP from 1998 to 2000, as well as dean of the same institute from June 1, 2000 to July 16, 2000. He is a convener and trustee of the Philippine Council for Islam and Democracy and the Philippine Center for Islam and Democracy, as well as a lecturer on the Muslim Christian commonality as conducted by the Sharia Department of the Philippine Judicial Academy from 2007 to the present. Currently, he lectures and provides reviews in two aspects. One, the Sharia training seminars, as sponsored by the National Commission for Muslim Filipinos, formerly the Office on Muslim Affairs, as well as an MCDE lecturer on Islamic law and electoral reform, as held by the UP Law Center in the University of the Philippines. He is also a professorial lecturer in comparative Islamic and civil family law in the University of the Philippines, as well as the Islamic Studies Law on Succession in the Institute of Islamic Studies in UP. Lastly, he is also a professional lecturer in constitutional law and administrative law in the College of Law of the Pamantasan ng Lungsod ng Maynila. In 2008, he was the chairman of the 11th Special Shari'ah Bar Examination Committee and served as a commissioner of the Commission on Elections from July 17, 2000 to February 2, 2006. He also served as commissioner for the National Commission on Muslim Filipinos in 2016, as well as the secretary of the National Commission from April 16, 2012 to April 6 to 2014. In 2017, he served as an examiner in the Political International Law Bar Examinations, and he's currently a senior lecturer of the Institute of Islamic Studies and in the University of the Philippines, Diliman, Quezon City. Ladies and gentlemen, to discuss the general views of the Sharia and its application in the Philippines, former COMELEC Commissioner and Attorney Mehol K. Saday. Good afternoon.
Good afternoon. Thank you very much, Attorney Ibanez, for that very kind and long introduction. I hope I'm able to do justice to that introduction. I may have a little difficulty speaking because I just had my denture on, but please bear with me. You know, this is a very timely lecture because I think even the Supreme Court is coming up with a technical working group to put in reforms in the Sharia judicial system in the Philippines. I was fortunate to be a member of that TWG. I was invited to sit with them, and I think they already had their first meeting. And the member justices already went around Mindanao and talked to the concerned parties there. Attorney Ismail invited me to talk on this. I think because I'm his teacher, so so he wanted me to be on board. But and he referred to me the title Nuances of Shari'ah. I think that is very appropriate because there's a lot of nuancing that we should do for our regular lawyers, members of the Philippine Bar, to understand what Sharia is all about. We are not just talking here of Sharia as practiced in the Philippines, because you know the lines of communication, technological developments that is currently happening has cut down our borders, no? And the Philippines, as we know, is a country dominated by Christians, but shall I say, swimming in an ocean of Muslims, Indonesia, Malaysia, and Brunei. No? And in fact, the most number of Muslims now are not in Saudi Arabia, not in the Middle East. They are in Asia. They're in Asia now. Around 170 to 200 million Indonesians, about 150 Malaysians, 100 million Pakistanis, and another 100 million Indians, totaling almost 700 million Muslims in Asia alone. And there will come a time that unavoidably, we will be dealing with, of course, these different countries, and our commercial law, our family laws will eventually intersect and interact with each other. So it's best now for our lawyers, regular lawyers, the non-Muslims, to know about Sharia. And I'm here to explain to you the very basic concept of Sharia, which all of us must understand before we can legislate things that affect the Muslims, or even think of programs that will affect the Muslims. It's always basic to know Islamic law. Can I please share screen? No? Pwede ba?
Yes, sir. We can see your screen, sir.
Okay na to, no? Can you see this?
Yes, but we can see them.
Okay. I'm just trying to find out how I can make this run, because I cannot. The black thing is let me just. Okay, here, slideshow.
Sa lower right po, sa lower.
Okay na,
right.
okay na. Nakita ko na. Nakita ko na. So, I had to minimize the screen, no, para makita ko yung nakasulat doon. Okay. I have around 20 slides, no? I think I'm given 40 minutes or 45 minutes. The first is the concept of justice in Islam. As lawyers, we always start with the concept of justice. These are verses from the Quran. Now, you might ask me, why do we have to start with the Quran? We are not into religion, we are into law. Okay, but the Quran provides us the basis of law for Muslims. The Quran. No? After the Quran, it is the traditions of the Prophet Muhammad sallallahu alaihi wasallam, which we call the Sunnah. So yung dalawa, Quran and Sunnah. You can never discuss anything about Islam without referring to the Quran. It always has to have a Quran basis. So, and to top it all, the Quran actually is a code of law. No? I shall show you later a very detailed verse in the Quran that talks about law. In fact, it talks about transacting futures contract, and that is in the Quran. It is contained in the longest verse of the Quran. For the Quran to have a legal matter in its longest verse, that would really tell a lot about the emphasis of Islamic law in reference to the Quran. And the Quran is also considered by the Muslims as the word of God. It comes from God. And therefore, all the injunctions in the Quran comes from God. So the one basic difference between Western law and Quran, and the Islamic law rather, is that in Western law, we have this theory, parang yung social contract theory, ang tawag yata doon, where men learn to assemble in communities, and in doing so, they found out that they have to regulate the matters among themselves so that they can coexist peacefully, and so they formulated laws. No? In Islam, it's the other way around. Before even man was created, there was already the law of God. So when man came down, of course, preceded by Adam in the story of the creation, which is also repeated in the Bible, the Genesis, man therefore coming to earth served as a vicegerent. The Muslims call it the Khalifa, under the leadership of the Khilafah. And as vicegerent, man was sworn to enforce, safeguard, enforce, and observe the laws that God has ordained for mankind. And that is now in the Quran. So the Quran says, The Quran says, when you judge among men, judge with justice. The concept of adil. This is something that should preoccupy mostly the judges. And in the second verse, I'm just picking out some of the verses. I'm not presenting all the verses in the Quran. There are a lot more. O you who believe, be maintainers of justice for Allah's sake, though it may be against yourselves, your own selves, your parents, or relatives. So this is a little different from our constitution, because we have the constitutional protection against self-incrimination. But here, the Quran, Allah in the Quran is saying that if you want to be really become maintainers of justice, you want justice to prosper in your area, you should even be a witness against yourself. That is how you bring about justice, or even your loved ones, like your parents or your relatives, if you are going to tell the truth. If you are really going to tell it, just like what we usually do before the courts, I swear to tell the truth and nothing but the truth. So that is this one is an embodiment of that oath that we take before the court. This second slide is still a continuation of the Sharia, of the Quran verses. To show you how the Muslims in the Quran, how the Quran looks at Sharia, which is Islamic law. Islamic law ang tawag natin dyan. By the way, when I use Sharia, I don't say Sharia law. That would be redundant. When you say Islamic law, that is correct. But Sharia by itself is already a law. So you don't have to say Sharia law. You just say Sharia. So the Quran in chapter 45, verse 18 said, Allah said in the Quran, we have put you on the way of Sharia, Shari'atul fil am. So follow it and not the fancies of those who have no knowledge. See, do you see the contrast there? This is the way of the Sharia. This is the right way given by Allah. That is Allah talking. We have put you on the way of Sharia. You follow it, and not the fancies of those who don't know, who have no knowledge about the laws that Allah has given us. That is a command to Muslims. And in fact, that I did not put the verse there anymore. There are other verses which say that if you don't use that, you are one of the disbelievers. That is how strong the Quran puts it, when it says that you have to follow Sharia. And then after this, there is some sort of a procedure that you have to observe. In Surah 4, this is Surah An-Nisa on women, and verse 59, it says, O you who believe, obey Allah and obey the messenger. Obey Allah, ati'ul Allah and ati'ul Rasulullah. And those placed in authority among you, the so-called, those in authority among you are the so-called ulul amar. Ulul amar. Amar is command. So ulul is the head, those who are in possession of authority. Obey Allah, obey the messenger, meaning Prophet Muhammad sallallahu alaihi wasallam, and then obey those who are put in authority. So even up to today, these are the people who occupy our government positions. These are the people who administer the country. These are the ones who are put in authority. And then it goes on to say, if you differ in anything among yourselves, refer it to Allah and the messenger. Now, since this is addressed to mankind, even to today's Muslims, then how do you refer it to Allah? How can you talk to Allah? How do you know that Allah is responding to you? How do you refer it to the messenger? The Rasulullah sallallahu alaihi wasallam is already dead. The meaning there is when you say obey Allah, of course you obey his commandments, what are his commandments in the Quran. Obey the messenger or follow the messenger. How do you do that? There is the sunnah or the traditions of the messenger, you follow that. And when you are told to refer it to Allah, you are told to refer it to the Quran and to the sunnah of the Prophet Muhammad. So you see, I will explain to you later, and this will make you understand, this provision will make you understand why the primary sources of Islamic law are the Quran and the Sunnah of the Prophet Muhammad, precisely because of these provisions. Now, there are two concepts that we have to be clear here. Sharia, which is Islamic law, and fiqh, which is the equivalence of jurisprudence in Western law. That is fiqh or fiqh. Sharia is law and fiqh is jurisprudence. The meaning of Sharia, very simply put, is this: the totality of Allah's or God's commandments. In its literal meaning, it is a path to the watering place. A path to the watering place. If it is the totality of Allah's commandments, then it means it is everything, all the laws, including natural law that Allah has given us. Not just man, but even nature. That is the meaning of totality of Allah's commandments. And it also covers the life of a man from birth and even inside the womb to death and even in the tomb. So it's from the womb to the tomb or from birth to death. That's how it looks like. And beyond that, in this so-called Yawmul Ahirah, the day of judgment, or the day when you are already, after death, after a man dies, he is still covered by the Sharia. The consequences of his action on earth is still would be inflicted on him. No? Would either be a punishment or a reward on him when he goes to the eternal life. That is the meaning of totality of Allah's commandments. Now, it is literally a path to the watering place. When you consider Sharia, which was revealed to the Prophet Muhammad, in Mecca, which is a desert, a watering place is a place of life. Okay, so when there is a path to the watering place, that is a path to life. That is a path that will give you life. That is a path that gives life. So Sharia, therefore, is a law that is supposed to regulate our lives so that we live a full life. That is the meaning of Sharia. In fact, the purpose of Sharia is to forbid what is wrong and enjoin what is right. Forbid what is wrong, enjoin what is right. And what is wrong and right are in the Quran, which is why one other name of the Quran is Al-Furqan, the criterion between right and wrong. Al-Furqan. Quran, by the way, means the recitation. So that is Sharia. That is Sharia. It is all encompassing. All encompassing. I was not able to put it here, but Sharia would include the matters of worship, which is ibadah. It will include the matters of belief, which is ihtikad. It will include also the matters of ethics and morality, which is adab. It will include the matters of penal law, which is uquba. And finally, it includes the so-called mu'amala. Mu'amala is civil and commercial transaction. Okay? The law that we have now, we lawyers, because I'm also a member of the regular bar, is what Sharia would call as mu'amala. Just one part of Sharia. It's mu'amala. Commercial as well as civil transactions. That is mu'amala. Now, we go to fiqh. Fiqh or jurisprudence, just like what jurisprudence really is all about, is the deduction or drawing out of Sharia values or rulings, so-called hukum Sharia, from Sharia evidence or sources, the so-called adillah Sharia in Arabic. So deduction of rulings from the hukum Sharia from the evidence or sources of Sharia, or the so-called adillah Sharia. That is fiqh. That is fiqh. So if you therefore compare it, although later on we will compare this, no? But just a short glimpse on this. If Sharia covers the totality of Allah's commandments, the totality of man's life, the totality of everything in nature, fiqh is concentrated on the laws that govern our relationship. So that is muamalah. No? Fiqh, most of the fiqh now, the working fiqh now, are concentrated on muamalah. The fiqh on ibadah, on adab, on ihtikad, they're already finished. Tapos na yan. We don't tinker with them anymore. No? We don't come up with new formulations on how to pray, on how to wash ourselves. We don't come out with new formulations on how our belief system should be done. No? But we have these formulations in jurisprudence on muamala and sometimes also in ukubah, the penal laws. Now, here is the comparison between Sharia and fiqh. No? Just short comparisons. First one is the Sharia to be found in the revealed laws of the Quran and the Sunnah of the Prophet Muhammad. These are inspired behaviors of the Prophet Muhammad, the traditions of the Prophet Muhammad. Then Sharia is fixed and unchangeable. Like I told you earlier, hindi mo na pwedeng baguhin. So that is the reason why it is embedded in the Quran and it is also in the Sunnah of the Prophet Muhammad, because these are two things that you can no longer change. Then the nature of Sharia is general and normative. It lays down basic principles, no? Basic norms, basic principles. Whereas fiqh is a body of laws deduced from Sharia or from the Sharia sources. No? Like I told you, from the Adillah Sharia, Hukum Sharia from the Adillah Sharia. Therefore, since they are deduced by the juries, the so-called fuqaha, the juries are called fuqaha, or the singular of that would be faqih. Faqih, the plural would be fuqaha. Just like you may be familiar with the term ulama. No? Ulama is the plural of alim. Alim is a scholar. So ulama are scholars. So when you say ulama, do not say ulamas anymore. Huwag niyo nalagyan ng letter S. That is already plural. Ulama, which is the plural of alim, and alim comes from the Arabic word alama, which is also the source of our Tagalog word alam. No? When we say alam, that is actually Arabic source. Alam, we know. No? To alama means to know, and to be an alim is somebody who knows. No? So the fiqh, therefore, is a jurisprudence that accounts for the changes according to the circumstances of the times. In other words, if Sharia is fixed and unchangeable, that is the aspect of Sharia. Fiqh is that aspect which is dynamic. It is the one that changes and adapts to the changing times. No? So Islamic law would be comparable to something that has a base, a firm base, and on top of that is probably a tree which you can decorate. No? you can put anything on that tree according to the needs of the times and according, of course, to the principles of that foundation that you have. No? Meaning the fiqh, even if you start doing your fiqh, you should always stick to the basic, the general and normative principles of Sharia in the Quran and in the Sunnah. Last, fiqh tends to be specific and demonstrates the basic principles of Sharia. No? So while Sharia is general and normative, the fiqh would be more specific, would be more demonstrative of the principles of Sharia. Let me give you an example. No? Offhand. In Islam, this so-called fornication or sex outside of marriage is supposed to be haram or forbidden. Let me first connect my power source. Now, very recently, we have now this technology or a medical technology that allows in vitro fertilization. I hope you're familiar with that. In vitro fertilization, where you get the egg of a female and the sperm of a male, join them together, put them in a womb, no, or somewhere else where it can actually grow. No? That is in vitro fertilization. We usually do that for male and females who are not able to have children, no? But they want, so that is done by the doctors. It is scientifically possible. Now, it is different from cloning. That's different from cloning. So that is IVF, in vitro fertilization. That is a new development, and so the fuqaha now of Islam had to formulate a rule whether that is allowed, fiqh, no? Whether that is allowed or not allowed in Islam. And they said it is allowed. It is allowed. But they stuck to the normative principle of the Quran. And the normative principle of the Quran says there should be no fornication. There should be no sex outside marriage. So they allowed it, IVF, but involving only a man and a woman who are married. Meaning you get the sperm of the husband and the ovum of the wife, and then put them together. You cannot get any surrogate woman for that matter. Hindi pwede ang surrogate pregnancy dito, no? Because that would be fornication. So that is an example of a specific ruling done by fiqh on a contemporary technological development, the IVF, but still basing it, no, putting it there based on the unchangeable normative value imposed by the Quran. Now, there are two, since we have Sharia, Sharia has a classification of acts, and fiqh also has a classification of acts. The classification of acts of Sharia are those which are more theologically based. No? So you have, let me just read the first column. The fardu or wajib, which is obligatory. The sunnah, mandub or mustahab, which is the recommendatory. The mubah, which is the indifferent or neutral. The makruh, which is reprehensible or disapproved, but not exactly haram. And then finally, the haram, which is the one that is forbidden. These are the classifications of act as we have it in Sharia. So the consequences are on in the two other columns. When you do in the fardu or wajib rather, fardu or wajib, the obligatory acts, when you do it, you are rewarded because it is obligatory. When you don't do it, you are punished. So example is prayer. And a Muslim prays, he is rewarded. When he does not pray, he is supposed to be punished. No? There's a punishment reserved for him. Then the sunnah, mandub or mustahab, which is recommendatory, it is something that you add up to your faith. No? So when you do it, you are rewarded. When you don't do it, you don't get any reward, you don't get any punishment because it is merely recommendatory. Then you have the mubah, indifferent or neutral. Whether you do it or you don't do it, it has no consequence because it is neutral. Although some Muslims say that if you do it in the way of Allah, there is supposed to be a blessing to it. No? So example of this is like eating, sitting down, walking, going back and forth, all of the ordinary things that we do. This can be classified as mubah, or where Sharia is indifferent or neutral. And then fourth, you have makruh, reprehensible. When you do it, it's okay because it is only reprehensible. It is not yet haram. But when you don't do it, you are rewarded. An example of this in the past is smoking. Smoking. No? Although smoking has been given now the category of haram because of the ill effects, no, on the health of a person. So there are now those who would say that still makruh, and those who say that it is already haram. No? There is a basis for this. Bakit pwede maging haram, pwede hindi maging haram, this matter of smoking? Because makruh can be divided into two. Yung makruh, this reprehensible. The so-called makruh karahat tanzi, the makruh that's still allowed, and the makruh karahat ta'rim, the makruh that is already forbidden. So let's go back to that example of smoking. If you smoke and you're still healthy, it is still makruh karahat tanzi because you're still healthy. But if you smoke and you already have tuberculosis, or you smoke and there are people around you who can be affected by I forgot the term. No? Smoking, it affects the other persons around you, the fellows around you. Then it becomes the makruh karahat ta'rim. Okay? And then finally, the forbidden. You get punished when you do it, and you are rewarded when you refrain from it. So that is the Sharia classification of acts. No? Sharia as the totality of rules. So you can see therefore that this classification of acts can cover all the actuations of a Muslim. No? All our actuations can be categorized under either fardu or wajib, sunnah, mubah, makruh, or haram. Nandiyan yan. Now let's go to fiqh. What are the classification of acts as per fiqh? Fiqh is the one now that would result from, for instance, the decision of a judge or the decision in court, no? Because this is now the one that results in jurisprudence. The first one would be sahih, no, or valid, meaning it is an act with full legal effects. So an act that complies with the requirements of law is a sahih act. Example, marriage. If the marriage complies with the articles on marriage in PD 1083, the Code of Muslim Personal Law, then it is a sahih marriage, and there are no impediments to the marriage. Next, you have fasid or irregular. These are irregular. It's like voidable, no? But not exactly voidable. It has selective legal effects, a few effects that are allowed to operate for fairness, no? And subject to ratification, but subject rather to ratification for full legal effects to operate. An example of this is marriage during iddah. Let me explain that iddah. Iddah is a waiting period. When a woman is divorced or the husband of a woman dies, she is told to observe an iddah, no, of 3 monthly periods. If it is death, there's an additional 40 days, no, for the respect for the dead. But it is usually 3 monthly periods. That is the iddah. That is the waiting period. The purpose of the iddah is, first of all, to effect reconciliation between the divorced couple, and second is to determine whether that woman is pregnant by the former husband. No? Determine the pregnancy. That is iddah. So when a woman therefore is divorced or her husband dies, and she is observing iddah, she cannot marry during that iddah. She cannot. That marriage will be irregular or fasid. Okay, you have to solemnize another marriage after the iddah is over. Same thing with maradul maut. Maradul maut is a state of death, no, a certain death. When a person feels that he is already dying, that is maradul maut. Hindi pwede magpakasal during maradul maut in Islam, no, because the one of the person who is the one the maradul maut is not in full possession of his or her capability or capacity rather to consent. So that is also irregular marriage. And second, third, there marami pa, but I just mentioned 3 is ihram, the state of ihram. State of ihram is the state of a person who is on pilgrimage. When a person is in ihram, in pilgrimage, he is wearing the white garment, two loose pieces of garment that he would wear for a man, and then one garment for a woman. Those who are in the state of ihram, meaning they are on pilgrimage, they cannot also marry. These marriages are fasid or irregular. You can only regularize them by a subsequent marriage after the impediments are over, no, or gone. And then finally, you have the batil or invalid or void, which has no legal effect at all. So marriages which are incestuous or the so-called unlawful conjunction, marriages which are so-called unlawful conjunctions, these are batil or invalid. No? A marriage which is called unlawful conjunction is where because you know a Muslim can marry up to 4 wives. No? So it is a marriage where a man would usually marry sisters, once 2 sisters, no, at the same time, because it is unlawful conjunction, because that is actually going around the law. that is it's as if you are fooling you're playing with the law, toying with the law, because once you marry a woman, you can no longer marry the sister of that woman, no? So some in the olden days among the Arabs, when the Arab would like two women who are sisters, he would marry both of them at the same time, so that the prohibition will not operate, kasi sabay sila kinakasal. But that is not allowed. That when Islam came, Islam prohibited that and called that unlawful conjunction, no? Lawful conjunction. Sources of Sharia. Ito na yung sinasabi ko sa inyo. The first two sources of Sharia are actually the Quran, which is the principal source, and the tradition of the Prophet Muhammad, the Sunnah. No? Now, by the way, the Sunnah of the Prophet Muhammad has been subjected to a lot of examination, investigation by experts, no? So that we are assured, or they are assured, the Muslims are assured that only the genuine and authentic Sunnah survive, no? And therefore are made basis of law. There are many Sunnah that by the way, Sunnah is tradition, and the writing is called Hadith, the Hadith of the Prophet Muhammad. You have the Sunnah, when it is written down, it's called a Hadith. The plural is ahadith, the Hadith and ahadith. So these scholars of the Sunnah and the Hadith have devised a way of examining the so-called Sunnah and Ahadith, so that they're able to determine whether these are genuine or sham Hadith, no, or fake Hadith, by tracing the transmissions. There is the so-called chain of transmissions from the last one that is heard up to the Prophet Muhammad. So there is if there is an unbroken chain of transmission, and all of these transmissions are proved to be authentic, then that hadith is authentic, and therefore it can become a basis of law. Otherwise, the hadith is either called a weak hadith or not a hadith at all. No, it is taken out of the book. So just to show you the tendency of the Caliph and the rulers of old, there were around, I think, 40,000 hadiths which were investigated, and only around 5 to 10,000 which were declared as authentic. No? So that's how it is. But right now, the so-called hadith exegesis has already been completed. So what consists of the hadith? The sayings of the Prophet Muhammad, his action, so-called, the saying is kaulun, fi'il, action, and then the tarir or silence or inaction of the Prophet Muhammad. The inaction of the Prophet Muhammad. Now, if you say now, what has this to do with our law? What has this to do with our law? These sources now, the Quran and the Sunnah, are mentioned in our law, no? Which is in Article 10, Section 3 of Republic Act 11054, which is the Bangsamoro Organic Law, and earlier, even earlier, in Article 4 of the Code of Muslim Personal Laws, although not as detailed as this, no, but it is mentioned there as the primary sources of law. The mention of this of Quran and the Sunnah is such that they are made as a basis for the construction and interpretation of the Code of Muslim Personal Laws by the courts, no? So meaning, when you file a case before the courts, and it involves a subject on the Code of Muslim Personal Law, the court now, when he decides, will have to decide on the basis of the Quran and the Sunnah of the Prophet Muhammad. That is what it means, no? And that is in our law now. Huh? What else? You have the different forms of ijtihad. Ijtihad comes from the word jahada, meaning to strive. No? So ijtihad is actually a legal nomenclature, which means that you have a judge, a fuqaha, a jurist, as well as a judge, will have to strive hard to arrive at a legal rule. This striving hard to arrive at a legal rule is called ijtihad, and it comes from the root jahada, meaning to strive, where the word jihad also comes from. Jihad, jihada. Jihad, which we know commonly as holy war, in jihad, no, holy war, comes from the root of ijtihad. No? So meaning ijtihad is the legal counterpart of jihad, no? Coming from the word jihada or the root word jihada. Here are the different forms of ijtihad. I cannot explain all of them in detail to you because that will take one semester, no? For us to explain that. Islamic law is taken up in UP as a one semester course. But we have ijma, which is consensus of the fuqaha, the ulama, meaning the learned people. We call this group ijtihad, no? Because it is also striving hard, but it is done by a group. And then we have qiyas, which is analogy. Analogy, you compare two things and you arrive at one ruling, okay, which is called analogical ijtihad. And then you have istihsan. This is a ruling based on juristic preference or equity. You have istisla, a ruling based on public welfare or public good. And then istishab, a ruling based on presumption of continuity. No? So our constitutional provision or the procedural provision in criminal law, which says that a person is presumed innocent unless proven guilty, is actually an example of istishab, no? Which is presumption of continuity of innocence unless the contrary is proven. You have urf or custom of the people. So meaning even our custom here, the customs of the Muslims here can be considered as Sharia, provided they don't violate the Quran and the Sunnah. No? And then finally, ito yung sinasabi ko earlier, no? When I said these are revelations to the Prophet Muhammad, Islam recognizes previous revelations. Islam is not exclusive. It does not say that religion was only given to Prophet Muhammad. No. Islam says that religion was given to Prophet Adam and so on down the line up to Prophet Jesus, Nabi Isa, and then finally Nabi Muhammad sallallahu alaihi wasallam. All of these are respected prophets in Islam. Adam, Abraham, Moses, Noah, Job, David, Joseph, all of this, they were given some of them were given their respective Sharia, no? Respective Sharia. And we call this Sharia of the previous prophets. This is, in Arabic, the so-called Sharia man qablana. Sharia man qablana, no? Sharia of the previous prophets. And they can also become sources of Islamic law, no? If they don't contradict the Quran and the Sunnah. No? The Quran has a term for this, aside from saying that these are kitab of the previous prophets, they're also called suhuf, no? Which are religious books. Now, here is an example of a Quran verse. At yung sinasabi ko sa inyo, di ba? I told you that the Quran is a source of law, no? And that there is a verse in the Quran, which is the longest verse in the Quran, which talks of law, which proves to you that Quran is really a legal code. No? It may have other matters, it may have other subject matters, but basically the laws of Islam are there. No? The laws. Even PD 1083, most of them are based in Quran, on Quran verses. So this one is the longest verse or ayat in the Quran. It is ayat or verse 282 in chapter 2, Al-Baqarah of the Quran. And let me just read the black and the bold letters. No? When you contract a debt for a term appointed, that refers to a contract on future transactions. No? Record it in writing. So that is recording, that is writing your contract. Let a scribe record it in writing between you justly. Again, the emphasis on the word justly. And let no scribe refuse to write, because Allah taught him how to write. That is his role. And let him, and then this one is really depictive of the mercy of God, no, to those who are the so-called borrowers, who are on the disadvantaged side of a commercial transaction, the borrowers. No, let him who incurs the debt dictate, and let him reverence Allah his Lord and diminish it not. So let the debtor dictate what has been agreed upon, and let the scribe write, but the debtor is not supposed to add anything to it, no, aside from what has been agreed upon, because that is what is just. But it is the debtor actually that should be able to control, no, how the debt would go on, no, how the repayment would go on. If he owes the debt, does not really understand, is weak in understanding, then let the guardian of his interest dictate justly. Again, the word justly is always put there. And call to witness from among your men 2 witnesses, 2 men. And if there is no two men are available, then a man and 2 women. Here, the equivalence of witnessing, no, one man. If you want to take the place of 1 man as a witness, you put in a woman. There has to be 2 women witnesses. Now again, the feminists have cried out against this. As nasabi nila, oh, unfair yan. Why do you require only 1 male witness but you require 2 male witnesses? No, a ratio of 2:1 if the female is a witness. It is not really unfair, because at the time when this was revealed to the Prophet Muhammad, the Muslim women were not really that exposed. They were not that exposed. So you can read there for him. It says that so that if one errs, the other can remind her. So that is the purpose. That's the purpose. It is for the testimony of a woman to be corroborated by another woman. No? Besides, under Roman law, alam naman siguro ninyo, the reason why it is called testimony is because only the males who have testes can testify. Katawag nila testimony or to testify. No, only male can testify. At least ito mabuti. Females, women are already allowed to testify. And my thinking here, no, if you really look at this very well, perhaps there may be instances later on where, because there is an exception to this, in matters where women are knowledgeable, then only 1 woman witness is allowed. In fact, no male witness can be accepted. And what is these matters? The matter of pregnancy, the matter of menstruation, the matter of childbearing. These are all matters that are the expertise of a woman. So that means, therefore, if there can be an exception to this, it therefore means that if later on there may be an instance or a case where only 1 woman knows about it, then 1 woman can become a witness. That is my thinking. Okay, that is more equitable. And then this one, unless it is a trade of present goods that you transfer among yourselves from hand to hand, then there is no blame upon you if you write it not. So this one here, the underlined portion, refers to our daily transactions in the market, no? Because we don't put them in writing. When you go to the market to buy fish or to buy vegetables, you don't put them in writing. This is the hand-to-hand transaction. No? And have your witnesses when you sell to one another. And let no harm be done to scribe or witnesses. Let no harm be done to the one who writes the contract, to the witnesses of the contract. If you do harm to them, it is a sin to you, sin for you. That is a witness protection program. That is the equivalence of a witness protection program. And it is there in the Quran. And then finally, I put this one in red because this will now drive the point that I was telling you earlier. In Islam, we look at the Quran because the Quran is the words of God. Now here is a verse, a legal verse from the Quran, the longest verse in the Quran, which talks about legalities. And then it concludes by saying, reverence Allah, ittaqullah, or have fear to Allah, have piety towards Allah, because it is Allah who is teaching you. It is God who is teaching you. So Muslims take this very seriously. Muslims take the Quran very seriously because the Quran is, Allah, God is telling us in the Quran, I am the one teaching you. You have to take this seriously. Now, we are all lawyers. Most of us are lawyers. We went through law school. We would tremble at the words of our teachers. And the teacher say, do you have a recitation? We follow that. The teacher says, you read 20 cases, we have to read all 20 cases. Here it is Allah telling you, you read these cases. You go through these provisions. This is my provision. You learn them. I am the one teaching you. So that is Quranic law. This is Sharia. This is the kind of Sharia now that has come into our legal system. It is not a fanatic kind of Sharia. Huwag kayong matatakot doon, no? Because I will not have time to discuss this, but the Philippines is a legally pluralistic country. And as a legally pluralistic country, it is bound to recognize the systems of law that operate within the country. So you have civil law or Western law, Westernized law. I would refer to the Westernized law or Philippine law. No? And then we have Islamic law, which is the one in PD 1083. And finally, we have customary law. Now, all of these are actually they form the dynamics now of our Philippine legal system. I don't have to discuss this with you anymore. Napapahaba lang ito. Okay, here are the Sharia in Philippine laws. If I will not have time, I will stop here. Please tell me kung ilang minuto pang ang available. First, you have persons and family relations. These are found in Presidential Decree 1083, which was enacted in 1977, if I'm not mistaken. This was during the martial law of President Marcos, where President Marcos was both wielding legislative and executive power. So persons and family relations, succession, a bit on the procedural aspect of practice. These are all in PD 1083, okay, the Code of Muslim Personal Law. Then we have the procedural matters promulgated by the Supreme Court, because of course the Supreme Court, we have the concept of the one Supreme Court. Supreme Court supervises all courts. Supreme Court actually writes all these rules, promulgates all these rules. So the procedural matters governing practice before the Sharia courts has an Arabic name to it. No, it is called Ijra'atul Mahakim al-Shari'ah, and it will be the topic later on, no, of one of our lecturers. Ijra'atul Mahakim al-Shari'ah, but it is a resolution of the Supreme Court, no? By virtue of the constitutional mandate that the Supreme Court actually exercises supervision and and administers the matter of practice before all courts, no, in the Philippines. Third, we have the establishment of the Islamic Bank, the charter of the Alamana Islamic Investment Bank, which is Republic Act 6848. This came from, again, another presidential decree. Then we have Republic Act 10817. These are the latest developments now in Islamic law, no, in the Philippines. The so-called Philippine Halal, the Export Development and Promotion Act of 2016. Halal is food that is legit to the Muslim, no? But it is food that is not exclusive for Muslims, meaning even non-Muslims can eat halal. No, this it does not have any spiritual effect on you. It does not convert you to Islam if you eat halal. It's like the kosher of the Jews. No? Diba meron silang kosher where they invoke the name of God and then they clean it. Same thing with the Muslims with respect to halal. So there is now a law on halal export development and halal accreditation. And this is Republic Act 10817, enacted in 2016. Then we have the Islamic Banking Act. The RA 6848 is just the charter of the Amana Bank. So it does not do anything to banking in the Philippines because it is the charter of just one bank, the first Islamic bank in the Philippines, the Amana Bank. RA 11439 is the Islamic Banking Act. This is the act now that allows Islamic banks to come to the Philippines. This was enacted in August 22, 2019. No? So that means there is now Islamic banking in the Philippines. But I would have discussed this with you, but we don't have time. My prognosis here is Islamic banking will not really prosper that much in the Philippines because there are three aspects of Islamic finance that are needed. You need Islamic investment, you need Islamic insurance, and you need Islamic banking. Absent any of these, the other two will be impaired. No? They will be crippled. And we don't have them as of now in the Philippines. Finally, we have Republic Act 11054 that I mentioned to you already, Bangsamoro Organic Law, enacted into law on July 26, 2018. This repealed the old law of the arm, 6734, as amended by RA 9054. So Republic Act 11054. Okay. Which actually came before the Islamic Banking Act. No? Pero hinuli ko na lang siya because this is the more encompassing law now, because it covers the so-called 5 provinces of the BARM, the Bangsamoro Regional Bangsamoro Autonomous Region in Muslim Mindanao, the BARM. What are the purposes of this code of Muslim personal laws? First, it recognizes the legal system of the Muslims in the Philippines as part of the law of the land and seeks to make Islamic institutions more effective. This is in Article 2 of the Code of Muslim Personal Laws. Second, it codifies Muslim personal law. In fact, the code that we have now is one of the first code ever worldwide that codified Muslim law in a non-Muslim country. And then C, it provides for an effective administration and enforcement of Muslim personal laws among Muslims. So this refers now to the court system, the Sharia Circuit Court, which is equivalent to the Municipal Trial Court, and the Sharia District Court, which is equivalent to the Regional Trial Court. No? Ito yung Sharia Court system. Of course, together with this, you also have the institution of the jurisconsult, the Mufti. You have the institution of the Agama Arbitration Council, which is like our ADR, the ADR in the courts that we have now. Construction interpretation. This is the one that I've been telling you. I referred to you earlier about the Quran and the Sunnah, and I told you that you might think that, oh, what is the Quran and the Sunnah doing in our law? Precisely because it is now part of Islam, of Philippine law. In the construction or to construe and interpret the code and other Muslim laws, the court, meaning the Sharia courts, and including the Supreme Court, because you can appeal up to the Supreme Court, shall take into consideration the primary sources of Muslim law. What are the primary sources of Muslim law? The ones that I mentioned to you. Quran, Sunnah, and Ijma wal Qiyas, no? Group consensus, analogical group consensus, and analogical rulings. No? These are the things that are considered as primary sources of Muslim law. In addition, you have the standard treatises and works of Muslim law and jurisprudence done by the so-called 4 major jurists of Sunni Islam. This is Al-Malik, Imam Malik, who founded started the Maliki school of law. And then you have Imam Hanafi, who started the Hanafi school of law. And then you have the Imam Hanbali, started the Hanbali school of law. Finally, you have Shafi'i, actually Shafi'i comes before Hanbali, who founded the Shafi'i school of law. And the Muslims in Southeast Asia are supposed to be adherents of the Shafi'i school of law. No? The Muslims in Saudi Arabia, they adhere to the Hanbali school of law. In Egypt, it's the Hanafi school of law. There are just minor differences here between the different schools of law in terms of the details, no? But basically, in terms of the general concepts of law, they all agree. Okay, finally, we're nearing the end already. No? The geographical jurisdiction of the Sharia district courts. I mentioned to you that the Sharia district court is equivalent to the regional trial court. No? So there are 5 Sharia districts constituted by PD 1083. No? The first Sharia district covers the province of Sulu. Its station, the Sharia district court, is in Holosulu. So 1 Sharia district court. The second Sharia district covers the province of Tawi-Tawi. And the Sharia district court, the second district, is in Bongao, Tawi-Tawi. Then you have the third Sharia district, which covers Basilan, Zamboanga del Norte, Zamboanga del Sur, and now Zamboanga Sibugay. It's a new province. And the station is in Zamboanga City, meaning the Sharia district court is in Zamboanga City. Then you have the fourth Sharia district court, which covers Lanao del Norte, Lanao del Sur, Iligan, and Marawi. Also in the third, Dipolog, Pagadian, and Zamboanga. No? The station is in Marawi City. And finally, you have the fifth Sharia district court, a Sharia district, which covers Maguindanao, North Cotabato, Sultan Kudarat. Now you have divided into Maguindanao del Sur and Maguindanao del Norte because of the recent plebiscite. No? The city of Cotabato, and it is stationed in Cotabato City. So those are five Sharia district courts in 5 Sharia districts. The only problem now is that there's only one Sharia court, Sharia district court, that is manned, that has a judge. The rest are actually vacant. So the judge now of the Sharia district court of Marawi City would go around these different districts so that he can entertain or hear the cases that have to be adjudicated. Yun ang kulang natin. In fact, there is a study which says that the lowest manning of the courts in the Philippines is in the Sharia courts. It is only around a little over 50% that are manned, unlike the other courts from 80 to 100%. So there is a dearth of judges who are occupying now the positions, or supposed to occupy rather positions in the Sharia court system. Now, after the Sharia district court, which is equivalent to the RTCU of the Sharia circuit court, equivalent to the lowest court that we have, the municipal trial court, the city court that we have now. In the first Sharia district, which is Sulu, there are 6 Sharia circuit courts. In the second Sharia district in Tawi-Tawi, there are 8 Sharia circuit courts. In the third Sharia districts, there are 10 Sharia circuit courts. In the fourth, there are 12. In the fifth, there are 15. So there are, I think, around 51. I did not put here anymore because I don't have the latest figure on how many are operational, how many are not operational. But most of those that are not operational are actually in the first, second, and third. The fourth and the fifth are usually manned already. They already have the respective judges. Do we still have time, Mr. Attorney Ibanez?
Sir, if we can wrap up soon, sir.
Pwede ba? How
Maybe
many
we
minutes
can
do I have?
3 to 5 minutes pa, sir.
5 minutes?
Yes, sir.
I'll just go through this very fast. Tatlong
Thank you,
slides
sir.
na lang at ito, 4.
Yes,
This
sir.
is Article 10 of Republic Act 11054. No, I included this. I think you will be given copies of this naman, di ba? They will be given copies. Anyway, I included this because this now sets the basic principles of the judicial system in the Sharia courts as found in the BARM. No? Now, please note yung kanina that I showed you, the regional the Sharia District Court, Sharia Circuit Court, geographical locations. Please note that not all of these areas are in the BARM. Because Zamboanga City, Zamboanga del Sur, del Norte, Sibugay, they are not in the BARM or in the ARM, the earlier ARM. Lanao del Norte is not in the BARM. Sultan Kudarat and North Cotabato, they are not also in the BARM. So please note, the Sharia court actually transcends the BARM. No? But this one covers, so in effect, therefore, if you have 11054, which covers the 5 provinces in the BARM, this can cover now the courts that are existing within the BARM. No? But still, the Supreme Court exercises authority or supervision over all of them. The only controversial part here is this 1, 2, 3, 4. The fourth one, let me just read this. Sharia shall apply exclusively to cases involving Muslims. Okay, where a case involves a non-Muslim, Sharia law or Sharia, ito na naman ang Sharia law, it is in the law, may apply only if the non-Muslim voluntarily submits to the jurisdiction of the Sharia court. The non-Muslim. You know, this can only happen if the Muslim and the non-Muslim married the Islamic way. If they married the Islamic way, the family affairs will be regulated by Islamic law. But if the woman remains a non-Muslim, then under this law now, this provision, she can invoke this voluntary submission and refuse to submit to the jurisdiction of the Sharia court in cases, for instance, of custody, no, or divorce, custody or divorce. Now, I said this is controversial because the problem here is the jurisdiction of the Sharia district court over custody cases, cases of paternity, filiation, legitimacy, is exclusive and original, or original and exclusive. So if it is original and exclusive, then it means you can only file it before the Sharia district court. Now, if the non-Muslim, even if she was married under Islamic law, refuses to voluntarily submit to the jurisdiction of the Sharia court will be left ineffective. And not only that, there will be no court that can entertain that case because the case is under the exclusive original jurisdiction of the Sharia district court. You file it before the RTC might just throw it out. No? So that's the controversy there. This is creation of the Sharia courts. No, you can just read through this. And then the parliament, because the legislature rather of the BARM is called the parliament. No, parliament. Hindi siya. The BARM is parliamentary in nature. So the parliament can enact laws involving ta'zir or criminal punishment, but only to a certain degree. The lesser crimes only punishable by arresto mayor or ta'zir, and or which is equivalent to arresto menor or fines commensurate to the offense. No? Okay, so that ends my discussion. You may ask questions later on if that is allowed, or probably after the lecturers have already given their lectures. Thank you very much.
Thank you again so much for giving us such an informative and detailed overview of the Sharia. There's really a lot to look at po talaga, ano po, despite the difference between how many laws there are versus the general law. And we look forward to learning more soon po. To move forward with our presentation po. And yes, of course, there will be an open forum later so that they can ask their questions. To move forward po to our next speaker. We'll be discussing the Muslim family law and the Presidential Decree number 1083, otherwise known as the Code of the Muslim Personal Laws of the Philippines. Our next speaker, Attorney Abdul Aziz A. Ismail, he obtained his Juris Doctorate from the Western Mindanao State University. He's a licensed professional teacher, a Sharia counselor at law, and as of now, a Sharia Bar Reviewer for the 2022 Sharia Bar Examinations with the National Commission for Muslim Filipinos in Zamboanga City. He is presently a partner at the Ijin and Ismail Law Offices in Zamboanga and is currently taking his Master of Arts in Islamic Studies at the Institute of Islamic Studies in the University of the Philippines, Diliman, Quezon City. He is also a member of the Integrated Bar of the Philippines, specifically the Zamba Sultan chapter, and is a member of the Integrated Sharia Bar of the Philippines, or ISBPI. Ladies and gentlemen, to discuss PD 1083, Attorney Abdul Aziz A. Ismail. Attorney Abdul.
Thank you so much, Attorney Jab. Can you hear me?
Yes, Patay.
Okay. If you would like to express our deepest gratitude to the IBP and to the other Sharia Bar organizations for having this Sharia webinar series possible. So if I may be allowed to share my slides.
Yes, Patay. All right, we can see your slides, Attorney Abdul.
Okay. So let's start. I am tasked to deliver the topic on Muslim family law in PD 1083. So the law is Presidential Decree 1083, promulgated on February 4, 1977 and took effect on May 16, 1977. Some call it CMPL, some call it PD 1083. However, in the latest case of Malaki versus People, the Supreme Court called it the Muslim Code. So we prefer calling it the Muslim Code. So it has 5 books and overall having 190 provisions. 45 years old na po yung batas. So what is the constitutional basis of the Muslim Code? since it was enacted in 1977. So it was created under a virtue of 1973 Philippine Constitution, Article 15, Section 11. However, in the case of Malaki versus People, the Supreme Court, having the same import, adopted Article 2, Section 22, and Article 14 of Section 17 of the 1987 Constitution. So, considering the customs, traditions, beliefs, and interests of national cultural communities in the formulation, implementation of state policies. So, having the same import with the provisions in the 1987 Constitution. How should the court resolve if there is conflict of laws? Well, this is a very interesting question. Under Article 3, in case of conflict between the provision of the Muslim Code and the general laws of general application. So, for example, the revised penal code having general application for those who live and sojourn in the Philippine territory, the Muslim Code, especially in Article 180, exempts Muslims from the crime of bigamy if they have complied or if they have made it in accordance with the provisions of the Muslim Code. So, should the conflict between any provision of this code and a special law, the latter shall be liberally construed in order to carry out the former. So, for example, PD 793, in which the law allowed divorce for Muslims according to customs and practices. However, such law never provided the grounds and basis for such divorce. So the PD 1083 or the Muslim Code was the one to provide such basis. However, according to Justice Daniel Rasul, the paragraph 3 of Article 3 is misplaced because it should have been placed in Article 13, which is the applicability provisions. However, the intent of the code, which states that the code shall be applicable only to Muslims and nothing shall be construed to operate to the prejudice of a non-Muslim. Okay. Question: is the civil code suppletorily applicable to the Muslim code? The answer will be yes, insofar as they are not inconsistent with the provisions of the Muslim code. What are included in the Code of Muslim Personal Laws? So, what are? So, it includes all laws relating to personal status, marriage, divorce, matrimonial and family relations, succession, property relations, specific offenses relative to marriages, creation of Sharia courts, Sharia registrar, Islamic jurisconsult, and Agama arbitration council. So these are the laws covered in the Muslim code. So it also has creation of these bodies. So a great question: when does Muslim code apply? Well, this has already been answered by the Supreme Court in Malaki versus People. So the Muslim code applies to marriages and nature, consequences, and incidents between, number one, fellow Muslims. In other words, the husband and wife are Muslims, married in accordance with Muslim rites. Number two, a male Muslim and a non-Muslim solemnized in Muslim rites. So you have a Muslim man marrying a non-Muslim woman, because under Islamic law, a Muslim woman cannot marry a non-Muslim man. Third instance wherein the Muslim code applies is spouses who both converted to Islam after their marriage. So this is a case wherein these are non-Muslims and then they converted to Islam, having the view of wanting to have a Islamic life. So the law, the Muslim code allows them to be converted to Islam, and such a way that they also want to have their marriage be governed by the Muslim code. The last one would be a male Muslim and a non-Muslim entered prior to the code's effectivity. So this is a case wherein a Muslim man married to a non-Muslim not in accordance to Muslim law before the effectivity of the Muslim Code. However, the two instances, Article 178 and Article 186, Paragraph 2, such conversion or option wanting to have their marriage be governed by the Muslim Code must not in any way operate to extinguish any rights or obligations incurred before such conversion. So we have the applicability provisions. The provisions of the code shall apply to marriage, divorces, wherein both parties are Muslims, so fellow Muslims, as what has been described in Malaki case. Or the second one, only the Muslim party, only the male is a Muslim party. Marriage is solemnized in accordance with Muslim law or this code. So in the second paragraph, we have, in case of marriage between a Muslim and a non-Muslim, solemnized not in accordance with Muslim law, the civil code applies. So in other words, even if you are a Muslim and then you have married in non-Muslim rights, then civil code, which is a general application law, would apply to you. And then we have the conversion, the third instance, wherein non-Muslim, a conversion to non-Muslim, the conversion of non-Muslim spouses to Islam shall have the legal effect of ratifying their marriage as if the same had been performed in accordance with the provision of this code, provided that there is no legal impediment to the marriage under Muslim law. So doing, well, the instance, this case happens when the parties or the couple registered their certificate on conversion and submitted to the civil register where their marriage is registered. And the last one, a marriage contracted by a Muslim male prior to the effectivity of the code. So again, the conversion and the option of wanting to be governed by the Muslim code shall not in any way operate to extinguish rights and obligations incurred before such conversion. So let's have a case. I would like you to have Rohaina Sumagka. It talks about the applicability of the Muslim code. Rohaina Sumagka versus Abdul Ghani Sumagka. This was in June 10, 2019. So here, the husband, giving you a factual background of the case, Abdul Ghani filed a case for divorce against his wife. Okay. Abdul Ghani are Muslims married in accordance with Muslim law sometime in July 18, 1998. However, after 6 years, they renewed their marriage vows under civil rights before a municipal mayor, Alaber of Sarangani province. So they had two marriages. First was under Muslim rights. After 6 years, they went to have renewed their marriage under civil rights. Now, when Abdul Ghani filed the divorce, Rohaina moved to dismiss the petition, alleging that the Sharia Circuit Court has no jurisdiction because of their subsequent marriage under civil law. So what did the Supreme Court say? Sabi ng Supreme Court, it is undisputed that Rohaina and Abdul Ghani are Muslims whose marriage was first celebrated under Muslim rights. This subsequent civil law marriage did not supersede their previous marriage, such that civil law would not govern. The Muslim code under which their first marriage was celebrated still applies. The first marriage is the validating right, while the second marriage is merely ceremonial. In other words, the law that governs the marriage between Abdul Ghani and Rohaina is still the Muslim code because their marriage was first solemnized under Muslim law. What did the Supreme Court say? The Muslim Code continues to govern the marital relations of Muslim spouses who first wed under Muslim law rights and decided to wed again under civil law rights. This is usually has been the trend before. They call it the first marriage doctrine. Ibig sabihin, ano yung first na batas na ginamit nila sa marriage nila, then that would be the one to govern, the validating one. The second one is only ceremonial. So that's the first marriage doctrine. So what is marriage in Muslim code? Marriage is not only a civil contract, but social institution. Its nature, consequences, and incidents are governed by this code and Sharia. However, the law provides that except it may be subject to stipulation regarding property relations. What are the essential requisites of marriage in Muslim code? So this is very important. Counterpart of Article 3 in the Family Code. No marriage shall be perfected unless the following essential requisites are complied. Number one, legal capacity of the contracting parties. This would pertain to the sex and the age and the sound mind of the parties. Mutual consent of the parties freely given. So there can never be a forced marriage in Muslim law. The woman must be asked if she wants the man. Number three, it's a bit unique. Offer the ijab and acceptance, kabul, duly witnessed by at least two competent persons after the proper guardian has given his consent. Number four would be the customary dowry, the dowry, the bridal gift to the woman. So these are the four essential requisites of marriage in Muslim code. What is the marriageable age in Muslim code? Under Article 16 of the Muslim Code, the male must be at least 15 years of age, and the woman must be at the age of puberty. So puberty has been defined as when the woman or the lady reaches or is having her menstruation. However, there is a presumption that she has already attained puberty at the age of 15. Later on, we'll have comparisons of the marriage under Muslim code and under family code. So kanina, what do ijab and kabul mean? So according to Attorney Alauya, ijab is an offer coming from the father or the authorized person. Kabul is an acceptance offer by a party to whom it is made. So example, no? Ang ginagawa dito, the father who solemnizes the marriage, the ijab would be, I give my daughter in marriage to you. That is the ijab, the offer. Now the man groom would say, I accept the marriage. So yun, the offer and acceptance, the kabul. So who are authorized to solemnize marriage in Muslim code? So let's see who are authorized. So marriage may be solemnized by the proper wali of the woman. So the wali here is the father or the paternal grandfather, paternal brother, paternal uncle. Because in Islam, the man is the custodian of women. We are the protectors of women. That is why before marriage, the solemnizing officer, if he was not authorized at that time, would seek who is the wali, where is the father. We would like to ask your consent so that we could solemnize the marriage. Without the wali, without the consent of the father, the marriage under Muslim law cannot be valid. Upon the authority of the proper wali by any person who is competent under Muslim law. In other words, this authority, so the first one, the first choice to solemnize the marriage is the father. However, if the father, for reasons personal to him, cannot or would not solemnize the marriage, he can just authorize somebody to solemnize the marriage. I hereby authorize you to solemnize the marriage of my daughter. Just like in Arab countries, usually here in Mindanao, if a Filipino Muslim woman or a non-Muslim Filipino would be wedded to an Arab, like in Saudi Arabia, in Qatar, in Kuwait, they would ask from the father, from the wali here in the Philippines, a written wali, so that the marriage will be solemnized in that country. So usually ginagawa dito parang affidavit lang, tapos ipapa-apostle. Because Arabs are having Sharia specifically in the marriage. So importante talaga yung authority given. So usually ito yung mga imam or ustads, if you see, but anyone can marry somebody provided he is authorized by the wali, by the father. Now, the third option would be the judge. If the Sharia district court judge or the Sharia district judge, should the proper wali refuse without justifiable reason. So the judge, if the father does not want or refuses to let her daughter be wedded to somebody who is qualified, then the judge, being the qadi, the authority, may be the one to give the proper authority for marriage. That's why in Islam, the father is given a better right than other people to solemnize the marriage of his own daughter. What is the default property regime in the Muslim code? Under Article 38 of the Muslim code, in the absence of any stipulation, the default would be regime of complete separation of property. So I would like you to have this case, Estrella Abid Babano versus Executive Secretary, August 28, 2019. So this case, Estrella Babano, giving a factual background, was a regional director of DepEd, and she was suspended for her failure to disclose in her SALN the motor vehicles belonging to her husband. So the argument of Babano was they are Muslims and their property regime was that of complete separation of property. So according to her argument, there is no need for her to declare the property of her husband. So what did the Supreme Court say? Babano and her husband were Muslims. Article 38 of the Muslim Code specifically defines the regime of property relations as Muslim to be one of complete separation of property. In view of Article 38 of the Muslim personal laws, the exemption of Babano from disclosure requirements should be clear and undisputed. Babano's non-disclosure in her SALN of the properties of her husband was not actionable. So the Supreme Court has followed the argument of Babano, considering that they are governed under complete separation of property. However, sabi ng Supreme Court, interestingly, similar consequences apply even to non-Muslims whose marriages, whose property regime is one of complete separation. So, of course, the Civil Code, superseded by the Family Code, has suppletory application. The Family Code the Civil Code and Family Code declare that each spouse shall own and dispose, possess, administer, enjoy their separate estate without need of consent of the other. So, accordingly, to still require public official or employee to include in her or her SALN the separate property of his or her spouse is inequitable as well as cumbersome. So for those who are still single here, although you are not a Muslim, babano case would apply to you. So the future, no, if you have the chance, if you're a government employee and would not want to disclose the property, separate property of your husband, well, it would be wiser to have your prenuptial agreement regarding your property regime under the complete separation property. That's the babano case. So who provides support, nafaka, for the family? So according to the Muslim code, it is the father, it is the man's duty to provide maintenance for the family. Who are entitled to support? So accordingly, the wife shall be entitled to support during marriage. And in case of divorce, her rights shall be extended up to the expiration of iddah, the waiting period, the 3 menstrual period. However, in the case of the wife is pregnant at the time of the separation, she shall be entitled until delivery. So if the divorced woman is a nursing mom and continues to breastfeed her child for 2 years, shall be entitled to support. So that's how Muslim code. It is the husband who supports the family. And if the woman spends for the family, then that would be considered as charity on her part. So question, is adoption recognized in Muslim code? The answer would be no. Under Article 64, no adoption in any form shall confer upon any person the status and rights of a legitimate child under Muslim law. So adoption is not recognized in Muslim law, Muslim code. So, well, this is the most celebrated question in our present time. Can a Muslim man be liable for bigamy if he contracted subsequent marriage? Well, my answer would be it depends. If he complies with the provisions of the Muslim code. Article 180, the provisions of the revised penal code relative to the crime of bigamy shall not apply to a person married in accordance with the provision of this code. Well, I highlighted in accordance with the provision of this code. Later on, we would know what that means. So according to the court, when we read Article 180, it should be read together with Article 27 and Article 162 of the Muslim Code, so that the Article 180 would apply to the Muslim. If not, then he may be liable for bigamy under Article 349. So, notwithstanding, this is Article 27. The rule of Islamic law pertaining to Muslim to have more than one wife, unless he can deal with them with equal companionship and just treatment as enjoyed by Islamic law, and only in exceptional cases. So this is somewhat the procedural, the formal requisite. A Muslim man desiring to contract subsequent marriage must file a notice, written notice of intent. And if the wife objects, then agama arbitration, the ADR, created in the Muslim code to convince the wife. If the wife does not agree to the marriage, then the court shall ultimately have the decision to sustain or not her objection. So before Article 180 would apply, it must be read together with Article 27 and 162. So this is the latest. This is a landmark case. Before, we usually have the first marriage doctrine. So long as you got married, the first marriage was under the Muslim code, then if you remarry, you are exempted from bigamy case. However, with this new case decided by the Supreme Court, penned by Justice Leonen, there is a stringent requirement for Article 182 apply. So giving you a factual background. Francis Malaki and Nerian married on March 26, 1988 under Religious Rights of Iglesia Ni Cristo. And then he contracted subsequent marriage in June 18, 2005 with Jacqueline Salanatin Malaki, solemnized by a municipal trial court judge. So both of them, Francis and Jacqueline, were charged of bigamy. So the argument, the defense of the petitioners, Francis and Jacqueline, was they are Muslims and they were married under Muslim law. Accordingly, yung sinasabi nating first marriage doctrine, according to them, they assert that prior to their marriage in June 18, before the judge, they were married already in June 5 under Muslim rights. So 13 days after. And moreover, additional argument was that, according to them, Article 3 of the Muslim Code, should there be a conflict? So parang they are into Article 180. The Muslim Code shall prevail. So accordingly, the Malaki doctrine answered 3 questions. Well, question number 1 was already answered. When does Muslim Code apply? Only the 4 instances a while ago that we have mentioned. The second question, is a party to a civil marriage who converts to Islam and subsequently marries under Muslim Code exempted from criminal liability? So the conversion, does conversion alone exempt you from criminal liability of bigamy? Can a Muslim man, third question, be liable for bigamy if he contracted subsequent marriage? So let's try to find out the answer. So according to the Supreme Court, conversion to Islam does not operate to exculpate them from criminal liability. According to the Supreme Court, granting that the Muslim convert is afforded protection by Article 180, that would be prejudicial to the abandoned wife, the state, and the aggrieved party in the criminal prosecution. So conversion to Islam does not operate. It's not enough. Indeed, in case of conflict between general law and the Muslim Code, however, the Article 13, paragraph 2, explicitly spells out that the Civil Code governs marriages where either party is a non-Muslim, which were not solemnized in Muslim rights. Sabi ng Supreme Court, there is no conflict between the civil law and the Muslim Code. The nature, the consequences, and the incidents for Francis and Nerayan remain well within the ambit of the Civil Code. He cannot successfully invoke the exculpatory clause in Article 180, considering that the Muslim Code finds no application in his then subsisting marriage with Nerayan. So the Supreme Court provided us with the substantive requisites with the Malaki case. Accordingly, Article 183 applies if you comply with Article 27. So Article 27 provides that there must be equal companionship, just treatment as enjoined by Islamic law, and only in exceptional cases. So before you may be allowed to contract subsequent marriage, you must comply. You must be able to give good equal companionship, just treatment, exceptional cases. However, this was not defined in the Malaki case, but we would be providing you with the opinions of the experts considered by the Supreme Court in the Malaki case. So first would be the opinion of Judge Ben Saudi Arabani. He defined equal companionship. It means that a man must be capable of giving equal treatment to his wives as regards requirement of the flesh, happiness of the heart, contentment of the mind. Are you able to give these 3? I think letter A, requirement of the flesh, happiness of the heart, would be very hard. Just treatment. means a man must be able to provide equally to his wives the necessities of life according to the social standing of the family. And Judge Arabani cited that Shafi'i school of thought subjected the permission of the plurality of wives to the condition of the husband's financial capacity. So, enough ba ang salary mo to provide for two families? Exceptional cases. So, mean that reasons must be meritorious, reasonable, and valid ground, or that is necessary and just. So these are the circumstances which would be considered as exceptional cases. Sterility, physical unfitness for conjugal relations, willful avoidance of decree of restitution of conjugal rights, insanity on the part of the present wife. So with these four exceptional cases cited by Judge Arabani, so the wife may not be able to bear a child, that would be considered as exceptional case. Again, according to Justice Jainal Rasul, equal companionship and just treatment presuppose physical and financial ability. Can you afford physically, financially? Exceptional cases may refer to situation where the intention aside from marriage is to help solve socioeconomic conditions. For example, a widow, a divorcee, orphans, and needy or poor woman would fall prey to the prostitution and immoral practice. And during disasters, calamity, catastrophe, or war, where the number of women far exceed that of a man. So these are the opinions of our Muslim jurists in the Philippines. So the first one was this substantive requisites. The second one would be the formal requisites or the procedural. The husband who intends to contract subsequent marriage must file written notice of intent with the clerk of court of the place where he resides. Now the clerk of court serves a copy to the wife. If the wife objects, the Agama Arbitration Council is constituted. So they will constitute. So the chairman of the Agama Arbitration Council would be the clerk of court of the Sharia court, and then the wife would send a representative. Likewise with the husband, sending a representative. So the purpose of the arbitration council is to convince the wife to the proposed subsequent marriage. And if the Agama Arbitration Council fails to obtain the wife's consent, now ultimately the court, subject to Article 27, just treatment, equal companionship, and exceptional cases, decide whether or not to sustain her objection. The court shall base its order on the report result of the arbitration. What if the wife consents? According to Justice Rasul, there is no arbitration. The clerk of court only issues a clearance stating the wife's consent to the marriage to justify the solemnization of the subsequent marriage. The Supreme Court said, in other words, the consent of the wife or the permission of the Sharia Circuit Court, if the wife refuses to give consent, is a condition sine qua non with respect to the subsequent marriage. So that is an integral part of the right to contract subsequent marriage. Absent the wife's consent or the court's permission, the exculpatory provision of Article 180 shall not apply, since it only exempts from the charge of bigamy a Muslim husband who subsequently marries in accordance with the provision of the Muslim code. In other words, if you don't comply, the Muslim husband does not comply with Article 27 and Article 162, substantive requisites and the formal requisites, then the Muslim man, even if his first marriage was under Muslim right, he may still be liable for bigamy. The wife's consent, the wife's knowledge of the impending subsequent marriage is essential and may not be waived. Accordingly, the subsequent marriage in the contemporary practice is not contracted in accordance with the Muslim code. Katakot-takot. Article 349 of the Revised Penal Code may validly regulate such subsequent marriage. In other words, if you don't comply with Article 27 and 20 and 162, Article 349 of the Revised Penal Code will apply. May pahabol pa. Moreover, failure to comply with the statutory requirements under the Muslim Code shall be punished by arresto mayor or a fine. This is exactly, this provision is under Article 183, an offense under the Muslim Code. So this is the gist of the Malaki Doctrine. Before, no? Kaya nga sabi natin before, the trend was the first marriage doctrine. Now, the Supreme Court added that Malaki case. The Muslim husband who contracted subsequent marriage, not in accordance with Article 27 and Article 162 of the Muslim Code, is liable for bigamy under Article 349 of the Revised Penal Code and offense relative subsequent to marriage under Article 183 of the Muslim Code. So that's it. Even if your first marriage was under the Muslim law or under the Muslim code, if you don't comply with the provisions of Article 27 and 162, then we have liability under Vice Penal Code, Article 349, and under Article 183 of the Muslim Code. So is divorce allowed in Muslim Code? Yes, the husband and wife shall have the right to divorce in accordance with this code. So the divorce, the absolute divorce, is recognized under the Muslim Code. So we have here the modes, 7 modes for divorce under the Muslim Code. We have the talaq, we have the ila, we have the zihar, we have the li'an, we have the khul, we have the tafwid, we have the fast. Anyway, the divorces under Muslim Code shall be discussed by another speaker as our Sharia webinar on Sharia proceed. So another thing. So this case of attorney siya, Attorney Marieta Zamoranos versus People. Criminal case for bigamy. So it was in 2011. So Attorney Marieta Zamoranos was a convert, a revert. Okay, got married with Jesus de Guzman under Muslim rights. So they got married under Muslim rights. But prior to that marriage, she was already a Muslim. Okay. And then again, on July 30, 1982, they renewed their wedding, their marriage, before the RTC judge in July 13, 1982. So after that, they divorced. They had a divorce by talak. So it was confirmed by the Sharia Circuit Court in Basilan. So terminated, dissolved ang marriage nila. Now she married Samson Pacasum under Muslim rights in Lanao del Norte. And on December 28, 1992, in order to strengthen the ties, they renewed their marriage vows in civil ceremony before judge of the RTC in Iligan. So in the end, it turns out, and then they had battle for custody. So Pacasum filed, cut the story short, Pacasum, the second husband, filed a complaint for bigamy. So according to the Supreme Court, Zamoranos is a Muslim, whose first marriage to another Muslim, the Guzman, was valid and recognized under Islamic law. Trying Zamoranos for bigamy would simply, because the regular courts have jurisdiction, would defeat the purpose of the Muslim Code. So stands to reason that Zamoranos' divorce from the Guzman was valid and thus entitled her to remarry Pacasum. So we're almost there. So comparisons between Muslim Code and Family Code. So we have the Muslim Code only focuses on the personal laws, while the family relations under the Family Code, we have also applicable only to Muslims under Article 3, 13, and the Family Code applies even to all Filipinos, even living abroad. The marriageable age would be 15 under the Muslim Code. Marriageable age under the Family Code is 18. And then the dower, the mahar, the dowry, is an essential requisite in Muslim Code, while it is not in the Family Code. Marriage license is not required in Muslim Code. Marriage license is required in the Family Code. So solemnizing officer, we have the judge in the Family Code, rabbi, minister, ship captain under Article 7 of the Family Code. But in Muslim Code, we have the father, the paternal grandfather, the authorized person, or the Sharia judge. And then we have foster. So this is an example wherein the child, the male child, is breastfed by a woman. So if he has been breastfed for 5 times within span of 2 years, he's prohibited to marry that woman. So, however, in Family Code, that is not an impediment. Divorce is allowed, while absolute divorce is not allowed in Family Code. You have separation, legal separation, declaration of nullity, and annulment of marriage. Plural marriages are allowed, of course, in accordance with Article 27 and 162 as provided in the Malaki Doctrine. That would be bigamous under the Family Code. Support is the sole responsibility of the husband, while the spouses are jointly responsible for the support of the family. And that the default would be complete separation of property under the Muslim Code, and the default would in Family Code would be the absolute community property regime. So what are the acts penalized in the Muslim Code? Only these 5. So Article 181, illegal solemnization of marriage. Article 182, marriage before expiration of the iddah. Okay, non-observance of the waiting period. So this is the offense committed if the marriage is not entered into or is not in accordance with Article 180, 27, and 162, offenses relative to subsequent marriage. And then the 4th one would be failure to report for registration. And lastly, Article 185, neglect of duty by the registrar. So this falls under the exclusive jurisdiction of the Sharia circuit. With that, thank you po. I end my.
Thank you so much, Attorney Abdul, for your inputs, which help us understand better the Sharia and the Civil Code and the application of Islamic law. I hope that in our future webinars, we'll be able to discuss these in more detail.
Opo, with others.
So stay tuned po for our open forum later. Our last speaker is a graduate of Bachelor of Laws at the MSU IIT College of Law Extension in 1997. He is a lecturer on Sharia law Sharia as a law subject at the MSU IIT College of Law since last year. Currently married to Samia Rumpak Ali with 4 children. He is currently a Sharia lawyer and the clerk of Court 2 of the 4th Sharia Circuit Court of Iligan City. Ladies and gentlemen, here to discuss the special rules of procedure in the Sharia courts, clerk of court and counselor at law, Nazaruddin A. Ali. Professor Ali.
I am permitted to begin.
Yes, yes, Professor. Yes, you can begin po. I understand that you, Johanna, will be sharing your presentation.
First of all, Bismillahirrahmanirrahim. First of all, allow me to extend the Muslim greetings to everyone. That is, Assalamualaikum warahmatullahi wabarakatuh. May the blessings and peace be upon us. It is a privilege and honor on my part to be invited in this Zoom webinar sponsored by the IBP to talk on the special rules of procedures in the Sharia courts. To begin with my discussion, may I venture to define procedure. To define procedure as established rules prescribing the manner or method by which the substantive rights may be enforced in courts of justice. The Philippine Sharia courts, being courts of justice, have our own procedures. And this is known as special rules of procedures in the Sharia courts. For brevity, we call it special rules. In Arabic, this is called Al-Ijra'at al-Mahakim al-Sharia, consisting of 19 sections, and this was promulgated by the Supreme Court in its in-bank resolutions on September 20, 1983. The promulgations of these special rules is actually based on the rule-making power of the Supreme Court as provided by the constitutions and as mandated by the Muslim Code found as provided in Article 148 and 158 of the Muslim Code, which provides that the Sharia district courts and the Sharia circuit courts may govern by special rules of procedure that the Supreme Court may promulgate. Based on that, we have these special rules of procedures in the Sharia courts. The special rules of procedures used to govern the entire stages of the proceedings in the Sharia courts with supplementary applications of the rules of courts and other Muslim laws. The objectives of the special rules is to achieve expeditious and inexpensive determinations of cases. That is to secure justice through expeditious and inexpensive determinations of cases. And this procedure is simple and devoid of dilatory tactics and technicalities to ensure the expeditious and inexpensive and speedy justice. The Sharia, the special rules, does not allow the filing of the following readings and motions, petitions and motions, namely the motion to dismiss on the civil case, motion to quash in the criminal case. Remember, we have the criminal case, but it is considered a criminal in nature, although these are specific offenses defined in the Muslim Code. And we have also the motion for bello particular. And the motion to dismiss, it is prohibited for the party to file it instantly. No? However, in our practice in the Sharia courts, we always reminded the defendant that that there was a memorandum of policy guidelines by the IBP and the OCA. These guidelines was dated in March 12, 2002, reminding the parties not to observe the unrestrained in the filing of motion to dismiss. However, they can allege that in their grounds for affirmative defense. In other words, the motion to dismiss can be alleged as a grounds in their defense. Okay. And likewise also, we reminded the party that should the party fails to file the answer as required by law, the court shall continue to proceed with the proceedings of the case and shall render the judgment based on the ex parte, I should say, ex parte proceeding will be observed by the court on the failure of the defendant to file his answer. Okay. So, motion to extension of time is also prohibited. Motion to declare defendant in default, that's also prohibited. However, the court shall, in motu proprio, can declare the defendant default in case the defendant fails to give the answer within the reglementary period of provided by law. Okay. And can proceed with the ex parte proceedings. The petition for certiorari, mandamus, prohibition against interlocutory order issued by the court. These interlocutory are just these are order, temporary order, granting the request of the parties, but this is not the final order, final resolution of the case. The petition from relief from judgment, motion for trial and reopening of trial, and any dilatory motion for postponement. So this in order to have speedy trial in the Sharia courts, these are prohibited. Okay, next slide, please. The commencement of action, all actions, whether it is civil actions, criminal action, proceedings in the Sharia court shall commence by filing of a complaint or da'wah. This complaint shall be preferred at least in triplicate by the plaintiff or by his or her counsel or wakil or by the clerk of court. This is a unique aspect in the Sharia, in the special rules wherein the clerk of court can assist the client in the preparations of the complaint. If this can be done if the complaint is illiterate and he has no means to pay the services of a lawyer. Now, in this case, the clerk of court may do the preparation, but it's a mechanical lang. No, what is being said, what is being told, yun lang ang isusulat niya. But he will not sign it as the complaint preferred by the clerk of court cannot be signed by him because kung siya magpirma dyan, lalabas na siya ang abogado ng party. Okay. Then, the complaint shall contain the following, no? The title of the case, the number assigned to it, the date of filing, the name and addresses of the plaintiff, and her counsel, if he has, the name and addresses of the defendant. Okay. Then the concise statement of the cause of action and the relief prayed for. Okay. This is the provisions of the special rules. The requirement by the rules of court of verification and certification shall apply to this, shall be observed. by the court, no? In case the clerk of court is the one who preferred the complaint, no? The verification and the certification. What if the complaint is preferred by the client and it is not verified? Will it automatically dismiss for lack of requirement, or yes, for requirement of verifications? No, the court will consider that, and that can be cured by 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 leave of court, requiring the plaintiff or the parties to have its complaint verified, and the certification and provided by rules of court shall also be observed. Not only that, it's not only the filing of the complaint, but also the payment of the docket fees as required by the Supreme Court. No, so the number of copies to be filed is not only triplicate, but more than that, because the number of copies to be written in the court is 2 copies, and 1 copy for the complaint for the plaintiff, and 1 copy intended to the defendant. So if only 1 defendant in a case, then the requirement of number of copies is quadruplicate. No? Kung dalawa ang defendants, so magiging 6 na kopya ang kailangan ng korte. Okay. So after filing of the complaint and the payment of the required docket fees provided by as determined by the court, then the summons together with the copy of the complaint shall be served upon defendant. Okay. The rules of court provided the services of summons by personal service. The mode of service of summons under rules of court is observed by the Sharia court. That is personal service of the summons upon the defendant. Then we have also this substituted service of summons. No, in case the defendant is not always by several attempts of the persons authorized by the court to serve the summons. Usually the summons is served by the sheriff or deputy sheriff. In the case of the Sharia Circuit Court, we have the persons who is called the process server. So the process servers will serve the summon. No, in case the person to be served is not always, despite of his several attempts, is not always in his residence, he can leave the summons to any person by tendering the summons to any person residing in that residence. Of course, that person must be of legal age, and he is a resident. He is a resident of that house. Okay. So if the defendant cannot be determined his whereabouts, no, despite the efforts, the inquiries done by the parties, by the plaintiff, no, the plaintiff can ask the court by leave of court to have the service of summon by publications. Okay. So publication will be granted by the court if it is meritorious. Then if the party is outside of the country, it is extraordinary service of summon. No? So those are the mode of summons, of service of summon and the rules of court that is observed, no? Observed by the Sharia courts. No? Then In the summons, the defendant is given the time frame to answer the complaint within 10 days from receipt. Okay, within 10 days from receipt of the complaint. Yes, of the summons, and it's either you will prepare personally the the complaint or the answer, I should say, then or by his counsel or with the assistance of the clerk of court. This is a unique aspect in the Sharia, in the special rules, where the clerk of court is authorized to prepare the complaint of the plaintiff, and he is also authorized to prepare the answer of the defendant. And he is the chairman of the Agama arbitration. The unique provisions. Okay. In case the section 5, in case the defendant fails to answer the complaint within 10 days, the court shall proceed to receive the evidence ex parte upon which judgment shall be rendered. Okay. So, although motion to declare defendant in default is prohibited, but if the court is the one declaring it in his motu proprio, that is in our courts, we are observing that if the plaintiffs, the defendant, I should say, fails to answer the complaint within that period given to him by law, then the court declare him in default. No? Then the proceedings of the case shall continue by receiving evidence ex parte. And if the evidence is enough to warrant the court to give the judgment, the court will render its judgment. Okay. Then the section 6 is the Agama arbitration, how conducted. In our previous lecturer mentioned about the Agama arbitrations. This Agama Arbitration Council is the efforts of the Agama Arbitration Council plays a very important role in the early disposition of the case. In other words, the participation of the Agama can abbreviate the proceedings of the case. The very purpose of the Agama Arbitration Council is to have this settlement of disputes between parties, amicable settlement of these parties. And of course, in the settlement of the disputes, the Agama arbitration shall consider the interests of the children and a third party involved. No? And for the speedy settlement of the disputes. No arbitration proceedings that will take place ex parte. No? So what will happen, how it is conducted when the case filed before the Sharia court is a case within the jurisdiction of the Agama arbitrations, where the lecturer mentions cases that are cognizable by the Agama arbitration. In other words, mandatory for the part of the Agama arbitration to be constituted when this case is happened. Like the case of divorce by talak at the instance of the husband. Agama arbitration should be constituted. Then another case is the case of tafwid. The tafwid that is to be initiated by the wife because of the delegations by the husband that the talak can be pronounced by the wife. Okay. So if the wife is now initiating that divorce, that top way, the Agama Arbitration Council will also be constituted. Another one is in the case of subsequent marriage. And where in case also, another one is if the wife is intending to practice his occupation or his professions, it must be the consent of the husband. So if the husband refuses to give his consent for the wife to practice his professions, then agama arbitration is to be constituted. Likewise, also in the cases that is against customary laws, no? Like breach to marry. No, there was a contract, then the other party, without justifiable reasons, refuses to perform his obligation to for the solemnization of the marriage. So, in other words, he refused to be married with the woman. Then in our courts, the agama arbitration, there are many cases in our courts that is resolved by the efforts of the agama arbitration council. The agama arbitration council consists of the clerk of court as a chairman, then at least one representative from the defendant, from the plaintiff, and one representative from the plaintiff. And there is no specific rules to be followed, no, or proceedings to be followed by the agama. They can adopt any method so long it is appropriate, no, appropriate, by taking into considerations the disputes, the conciliation of the parties, and the entries of the children. Okay. If the case is not settled by the agama arbitrations, then the next procedure is pre-trial. Pre-trial. Okay. In the pre-trial, there is a period of 30 days after the answer is filed. The 30 days period given by the court or by the rules is for the parties to condition their mind for possible amicable settlement. No? For amicable settlement. After the 30 days, that is enough period for the parties to consider amicable settlement of the case. If after the 30 days period, then the case shall be calendared for free trial. Should the party fails to arrive at amicable settlement, the party shall clarify and define the issues of the case, which shall be set forth in the free trial order. There are two purposes of the free trial. One is for amicable settlement. Number two is for the court to define and clarify the issues of the case. Okay. The requirement of the rules of court that 3 days before the pre-trial, the parties are required to submit pre-trial brief. This applies to the special rules, to the Sharia court. The judge usually issued an order requiring the party to have this pre-trial brief in order to assist the court in the determinations of these issues and the issues to be clarified and to be defined, and for the court also to know whether the parties are willing for amicable settlement. Okay. If the parties refuse to submit this pre-trial, then the pre-trial will go on. It will not penal bother the the, the schedule of the pre-trial. If the case is within the jurisdiction of the agama arbitrations, and the settlement introduced or efforts by the agama arbitration is not is failure, then the case will be for pre-trial, that is no longer observing the amicable settlement. The court shall automatically proceed with the clarifying and defining the issues of the case. Okay. After the court has defined and clarified the issues, the court shall set forth that in the pre-trial order. Then the parties are required to submit within 10 days upon receipt of that order the statement of witnesses in form of the judicial affidavit and other evidences like agreement or written pertaining to the issues to clarify and define, together with the memorandum. In the memorandum, they will set forth the law and the facts relied upon by them. No? Okay. Upon submissions, upon submissions of this memorandum, together with the statement of witnesses and other evidences by the court shall, if it finds it that there is no need for further trial, that the available pleadings and evidences available is enough to give judgment, the court may do so. May do so after 15 days from the submission of the decision. If there is no need for further trial because the submitted memorandum, and evidences submitted are enough for the court, for the judge to give the decision, that can be done. No? Okay. Actually, this special rules of procedure, the special rules in the Sharia court is the summary. The same with the summary rules of court in summary procedure in several cases. Yes, similar. Okay. Then after the pre-trial, then the trial of the case. Slides, please, for the trial, section 7. Okay. Section 7 is referring to the hearing or the trial. That is, after the court have received the memoranda and the court believes that there is a need for further trial, then the trial will be scheduled. No, and there are three events in the pre-trial, in the trial of the case. One is if during the trial, the plaintiff has no evidence, because supposed to be the plaintiff is the one who has the burden of proof to prove his claim. But during the trial, he has no evidence. No? And the defendant can challenge the defendant to take an oath. No? And if the plaintiff of the defendant shall take an oath, judgment shall be rendered in his favor. And this is a situation where the plaintiff, during the pre-trial, he mentioned he has manifested that he has the evidence. But when the trial comes, the evidence mentioned by him is not available. Okay. So he is supposed to be has the burden of proof. So he can ask the he can ask challenge the defendant to take an oath, no? To take an oath. If the defendant shall take an oath, the judgment shall be rendered in his favor. Should the defendant refuse to take an oath, the plaintiff shall affirm his claim under oath, in which case judgment shall be rendered in his favor. Should the plaintiff refuse to affirm his claim under oath, the case shall be dismissed. No? This is a very unique provisions, but because of this yamin introduced in the special rules, no, the judgment of the court becomes valid even without evidence. But these provisions, this paragraph 1, was declared unconstitutional in the case of Tampa versus Usman. No, because it is contrary according to the ruling that these provisions is contrary to the constitutional requirement of due process, the right to confront the witness, the right of due process, no? And there is even the threat that this provision will be subject to amendments, no? But there are some lawyers, Muslim lawyers, who have said that that decision, that opinion is just an obiter dictum, no, of Justice Gangayko. Oh, actually, these provisions is taken from the Quran, from the Islamic law, I should say, from the Islamic law. No, this is coming from the Hadith of Prophet Muhammad. If he has no evidence to prove his claim, he can ask the defendant for an oath, because the presumption there is the classic theory under Islamic law that the presumption is there is no Muslim that will lie under that will lie in the Quran, no. No Muslim will lie in the name of in the name of the Holy Quran, no? In the Holy Quran, when the person submit himself for an oath, he is not telling a lie. No, he's not telling a lie. No, and that is a classical theory that Muslims do not lie under Quran, under the Holy Quran. No? Okay. And for me, unless this provision is deleted by the Supreme Court, this provision should stay in the rule, in the special rule. No? In the special, unless it should be observed. Our court is still observing this one, unless this is amended. This is amended by the Supreme Court. If another situation that the defendant admits the claim of the plaintiff, judgment shall be rendered in his favor without further receiving evidence. The number 3 situation is if the defendant is offering defense, no? And likewise also both parties have the evidence and they have all the to support their claim and the evidence of the defendant to support his denial, then the case will be for closing for the case should be calendar for trial, no, wherein the defendant the plaintiff will be the one first to present his witnesses, no, and the defendant will be the one who will cross-examine the defendant, then redirect and recross. Okay, so this, if after presentation of the judgment, the 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 judgment after the presentations of the evidences, the court now can give the judgment on the merits of the case. Okay. So after the trial, the the section the we have also the section 13A, the administration of oath, no? The oath that is legally binding in a manner and form observed under Muslim law. The kinds of oath, the format of the oath is the one that is being done by during the time when the Usman render or talk his oath, no? And the format of that can be accepted, no, as the form the format of the oath, no, to be observed. Okay. Then by order of the court, the parties who are most tend to establish a fact, affirm the evidence by present, such as may constitute a proof in absence of other evidences. No? Then no person shall be allowed to take an oath unless he is qualified under Muslim law and he is fully aware of the solemnity of the oath or the import of the solemn affirmation. Any person who is to take an oath or solemn affirmation in accordance with the Muslim law shall be given reasonable time to think it over. If the defendant is willing to take an oath, you will be given enough time to think. It is not immediately. The court will designate the time when the oath is to be administered. Okay. The court shall set an appropriate time, the date and the place of oath taking, or the solemn affirmation of that person. If any time before such appointed date, the party who is required to take an oath or solemn affirmation refuses to do so, the court may in its discretion direct the person, if the plaintiff, to withdraw his claim, in the case the defendant to admit the claim, the plaintiff. Okay. So kung ayaw ng after the date has been designated, then the ayaw ng plaintiff to continue the taking of oath, then he will be directed by the court na i-dismiss yung kaso, i-withdraw yung kaso, or kung defendant siya, to admit the claim. Okay. After that, we have this section, slides please, the mutual oath, the ta'aluf. In case of claims, there is a claims and there is a counterclaims where neither of the party will give way at the pre-trial, and the court may, in its discretion, require parties mutual oath for any particular facts or facts upon which the court may render judgment. This is a situation where the plaintiff and the defendant, both of them have no evidence on the part of the plaintiff to prove his claim. And likewise, the defendant has no evidence to deny the claim. But they are willing. Both of them are willing to take oath. Willing to take an oath during the pre-trial. Okay. In this case, the court, well, if both parties are willing to take an oath with no evidence, the case the court shall render the judgment dismissing the case. No? Because both of them are the presumption that both of them are telling the truth. No? No one of them is lying. Oh, okay. So this is the dismissal of the case. Okay. Then section 15, there is that mutual imprecation. When a Muslim husband accuses his wife of adultery and fails to prove, and this is a situation when the husband accuses his wife of illicit acts, no, but there is no evidence on his part to prove that allegation, and the wife, likewise, the wife also is denying the accusation. So the court will now do is to let the party performs the prescribed acts of imprecations. These acts of imprecations, letting the husband to utter his accusation in 4 times. Then after the four times utterance of the accusation, then the defendant, the wife, I should say, the wife also will also have the denial, no? The denial of the accusation. Then in that way, the court will render judgment dissolving the marriage, no? Issuing the divorce decree. Because in that manner, there is already the loss of love. There is already that companionship is no longer exist in that kind of relationship wherein the husband is accusing of his wife of in adultery. No, so there is no harmony, there is no happiness in that kind of relationship, other than the dissolution, the dissolutions of the marriage. Okay. Then the section 8 is about the judgment. The judgment shall be rendered within 15 days from the termination of the trial or the disposition of the case, should there be no form or other trial or hearing. Okay. The decisions in the Sharia case, to be clear, is classified into 6. We have this judgment on the merit. This is a kind of judgment refers to the decision rendered by the court after formal hearing. After formal hearing or trial. It must be in writing. The decision must be done personally, no, by the judge. Okay. So the acquisitions, or sometimes the impression that the decision is done by another persons or by, is not true, because under the law it is the judge who will personally and directly refer the decision. Okay. And in the decision, the judge will state, shall clearly and distinctly state the facts and the law on which it is based. So the facts and the law must be indicated in the decision. Okay. Another kind of judgment is judgment by default. Judgment by default is one where the defendant fails to answer the complaint within 10 days from receipt of the summons. A motion to declare him default is not allowed, but the court shall not approve to declare him in default, and thereafter proceed to receive the evidence of the plaintiff ex parte. On the basis of the evidence presented, the court shall render its decision. Judgment by default shall become final and executory after 15 days from termination or disposal of the case. Party who is declared in default loses his right to appeal. Okay. Then number 3 judgment is judgment on the pleadings. After the court has clarified and defined the issues involved in the case, He shall now issue an order requiring the parties to submit within 10 days within 10 days the statement of their witnesses, sisuhod, the other evidences, bahina, pertaining to the issues so clarified and defined, together with the memorandum, setting forth the law and the facts relied upon, if the court finds, upon considerations of the pleadings, the evidence and the memoranda, that judgment may be rendered without need of formal hearing, it may render its judgment. And the judgment of the pleading shall become final and executory after 15 days following the terminations of the case. Then number 4, judgment upon compromise. Judgment upon compromise is that which is entered into by virtue of compromise or agreement between the parties. However, the compromise agreement shall not be contrary to law, public policy, public order, public interest, good customs, and morals. As a rule, judgment upon compromise shall become final and executory. Okay. Then judgment upon admission. Judgment upon admission takes place when the defendant admits the claims of the plaintiff. In other words, the admission be valid. It must be voluntary. In order that the admission is valid, it must be voluntary, not obtained through force, fraud, violence, or intimidation. Once the defendant admits the claim of the plaintiff, judgment shall be rendered in the favor of the plaintiff. Okay. Then the last is judgment upon oath. And the judgment of the court is based upon oath of the party. If the plaintiff has no witnesses, he may challenge the defendant to take an oath. And if the latter takes the oath, judgment shall be rendered in his favor. And if the latter takes the oath, judgment shall be rendered. If the defendant refuses, the plaintiff may affirm his claim under oath, in which case judgment shall be rendered in his favor. However, if plaintiff refuses to affirm his claim under oath, the case shall be dismissed without prejudice to damages that it may be awarded to the defendant. So the losing party or the aggrieved party after the judgment may appeal the case. If the case is decided by the Sharia Circuit Court, he may appeal the case to the Sharia District Court by notice of appeal, by submitting the notice of appeal and the payment of the docket fees within 15 days from the receipt of judgment. Now, if the appeal is done beyond the 15 days period from the receipt of the judgment, the appeal is already no longer available. Okay. The appeal to the Sharia Court, Sharia District Court, is perfected from the appeal fee, the clerk of court transmit upon, in the case of cases appeal to the Sharia District Court, when the clerk of court received the notice of appeal and the payment, the required legal payments, the entire record shall be transmitted to the Sharia District Court. No? And the same thing, if the case is at any rate, the decision of the Sharia District Court is final and executory, without the prejudice, however, to the losing party to file a petition for review or certiorari. Pero that is a separate case, that is a special civil action. Okay. Then the same thing, if it is to be filed for petition for certiorari, all their entire records, exhibits will be submitted submitted to the Supreme Court. Okay. Section 12 is the legal opinion, fatwa. Before the judgment, this is very important, and this is, the opinion of the jurisconsult is also very important to have the judge in its decisions credible on very because the judgment that is with the opinion of the jurisconsult is somewhat the judgment is also credible, no? Credible. Okay, but the opinion of the jurisconsult is not mandatory to be considered by the judge. The judge may adopt or may not the opinion of the jurisconsult, and these provisions, because of the presence of the basic organic law, change this provision into mufti. This is no longer observed, no? Observed because of the amendment introduced by the law that created the Bangsamoro or Bangsamoro Regional Autonomous Region in Muslim Mindanao, the 11054, no? Wherein the opinion, the office of the jurisconsult was changed, no? Was changed, but the opinion of the jurisconsult being knowledgeable of the law, it should be considered, no? Should be considered, and then very important before the judge will give judgment. Okay, then the last section is we have the supplemental rule in several cases on Muslim law on evidence. The court shall adhere to the sources of Muslim law relating to the number, the status, the quality of witnesses, adala, and evidence required to prove any fact. And the role of evidence and to be observed in the Sharia courts, the Muslim law shall be adopted, no? As to the number of witnesses. In case is about contracts, how many witnesses is required, no? The status, okay. The status refers to whether the witness is a Muslim or not, no? The credibility of the witness. The witness who is not a Muslim is not qualified, no? Is not qualified to be a witness, no? Likewise, if the person is known to be liar, is not qualified. The statute refers to the credibility, no? The credibility of the person giving testimony, no? Is number two is the one is should be honest. The ones to be credible witness is an honest person, and he is a Muslim, and he is not known to be a liar, no? Known to be liar, and he should be an impartial person. Okay, that is the status. The quality of witnesses is provides the qualification of a witness. He must also be a Muslim, no? Muslims, and he is not insane. He is a person with good memory, no? And he is not impartial. Okay, and the evidence under Muslim law is it has 4 ways to proving cause of action. It's either by admission or by testimonial evidence, no? By giving testimony, or by oath, yamin, or other evidence, bahina, that is mga public documents, whether the document is in a public form or private form, no, so long it is accepted, no, by the court. Then the rules of court is also applied in suppletory manner, no? So as to the number, status, the quality of witnesses, the Muslim law shall be applied. In the case of the civil actions, no, the rules of court also will be applied in suppletory manner. Okay. Suppletory rule in special offenses, subject to the next proceeding section. All special cases or offenses cognizable by the court may be filed in such a form and heard in such a manner as prescribed by the applicable laws and the rules of court. However, the court may apply in suppletory manner the principles of Muslim law. So in the case of special offenses, like the case of illegal solemnization of marriage, the subsequent marriage without the permission from the court or the consent of the wife, the failure to observe the registrations of status of a person from single to married to divorce, no? This is specific offenses. Or another one is the illegal solemnization of marriage, no? So these rules is governed by these rules of court in summary procedure and for the criminal cases, no? Criminal case, summary procedure, criminal cases. As to the number of witnesses, to the quality of witnesses, the principles of Muslim law is required. The evidence, no? The evidence to be presented must be in accordance with Muslim law or Islamic law. Okay. Then the last one is the effectivity. The special rules of procedure shall take effect immediately. Okay. It was approved on September 20, 1983. So that's all. Thank you very much.
Thank you very much, Professor Ali, for that very detailed overview po of the procedures. Malaking tulong po sa pagkakaintindi po. And at this point po, we'd like to ask our 2 other speakers to also go on campo. We just have several questions po. No? Some of our questions were already answered by the discussions, but due to also a lack of some time, we will be limiting the questions. But maybe we can also email some of the questions to you later po that maybe you can answer in a future webinar perhaps po, or through email as well. So I'll go na lang po dun sa first question. Let me just call the other participant, other speakers lang po. And then maybe Professor Mehal Sadain also. Ayun po. Good afternoon po again. Thank you for providing us this information po. No? We're very appreciative of it po. At the same time po, we'd like to if I go on na po dun sa questions po, no, for a moment. First one, no, this refers to the judges in Sharia courts. No? There was a list shown earlier, and it was mentioned by Commissioner Mehol Saday that there is really a lack of judges in the Sharia courts. In connection thereto, is there any explanation why there seems to be a lack of judges? And in connection to the said question, how does this affect the congestion of cases in Sharia courts? Siguro po, we can start with Professor Sadain po.
Thank you very much for that question. You know, for a very long time, when I was still quite active in UP, we did a survey, you know, of the cases that were being filed before the Sharia court. Sad to say, the caseload for Sharia courts were not that heavy at that time. No, and this is probably the reason why the manning in the Sharia court dwindled. No, in through time, merong mga Sharia courts na hindi na na-fill upan kasi nga hindi rin naman talaga maraming kaso na ipa-file, no? But I don't think it should be seen in that manner because the Sharia courts have their respective jurisdictions. So even if there are not too many cases, for instance, filed in Tawi-Tawi or in Holo, still you need a Sharia district court there for those who are minded to file cases, di ba? You need a judge to man those courts, and not just the Sharia district court but also the Sharia circuit courts. So yung AAC, as I explain usually to my class, the AAC, Agama Arbitration Council, which is a form of ADR, was instituted by virtue of a Quranic verse which says that it is always best to reconcile parties. No, if you fear that there's going to be a breach between two parties, you have to bring them together so that they can reconcile. So in short, it is the need for reconciliation. Unlike sa ADR, if you study the ADR law, this came from the Katarungan Pambarangay, no, and then it went down. It went to, before it became a court-aided ADR. The need for the ADR actually was to unclog, di ba, the load of the courts, unclog the caseloads of courts because there were so many cases being filed in the regular courts. So magkaiba yung rason kung bakit kailangan mong magkaroon ng ADR, kailangan mong iman yung mga courts, magkaiba siya. While in the regular court, you need to man the regular court because of the cases that are coming in. In the Sharia Circuit Court, you need to man them because there are actually cases that need attention. No, not only within the Mindanao area, but even outside. There are Muslims as far north as Tuguegarao, Muslims in Metro Manila, throughout Luzon, in Eastern and Western Visayas, and they cannot. There's no court that can entertain their cases. So what they do is they do the next best thing is to go to the Sharia court that is nearest to them, most accessible to them, to file their cases there. So it's actually a matter of making the courts accessible to the parties, no? And probably once accessible, there will be more cases that will be filed. Yun ang observation ko. No?
Thank you very much, Attorney Mehol. Siguro nasagot niyo rin po actually yung follow-up question. And the follow-up question was, what would be a Muslim or a person under the Islamic laws that lives in Metro Manila or in a region without is supposed to do? So medyo na-mention nyo nga po is to go to the nearest Sharia courts.
Yes, they are given the option to file their cases before the nearest Sharia court or the most accessible and convenient Sharia court where they can file. So usually, if you live here and you are a Muslim from Lanao, you file before the Lanao courts. If you are from Maguindanao, you file before the Maguindanao courts. If you are from Sulu, Tawi-Tawi, or Basilan, Zamboanga, you file before those courts that are based there. There's no problem with those who have hometowns to go back to, no, meaning the native Muslims. The problem is with the converts or reverts, as we call them, who are staying here in Metro Manila and they don't have provinces in Mindanao, as well as those who marry Muslims. Those who marry Muslims, you know, when a long time ago, the Committee on Justice, chaired by Senator Escudero, Chief Escudero, came up with a public hearing, and we presented our papers there. This was, I think, when I was still active in UP. I'm retired now. I just lectured there, and we told them that the people who stand to be benefited by additional Sharia courts outside of Mindanao would be this is ironical, would be the non-Muslims, particularly those who marry Muslims and then who encounter problems later on. We have had so many cases already of non-Muslims coming to us asking that they get a divorce from their Muslim husbands, but they cannot file a case here because, I mean, there's no Sharia court here. So they ask us, where can we file cases? So we refer them to courts that are familiar to us.
Opo. So thank you for that po, Professor Sadain. This question po is addressed to everyone po, no? Can lawyers or regular members of the bar appear in Sharia courts? Maybe Clerk Ali po, Professor Ali. Opo.
Yeah,
Being in a
yes.
circuit court po.
Yeah. Lawyers can appear to all courts. No preventions with them to appear before the Sharia. And in fact, many cases filed in our courts are represented by lawyers. So in fact, not to say anything against the Sharia lawyers, but the presentation of a lawyer in our courts is something is presentable. The arguments of a lawyer is really very effective. Also, it does not mean that the arguments of the Sharia lawyer is not. It is also effective, but it is different when a lawyer is the one arguing the case.
Thank you for that.
Lawyers, members of the IBP are welcome. Are welcome to appear before the Sharia Circuit Court and even in the Sharia District Court.
Thank you for that, Professor Ali po. Then we delve into the more specific po, no? Tama po kayo, Attorney Abdul, no? Talaga may matatanong about marriage, no? Being one of the more common or topics po of Sharia. Excuse me. The first question po, no? We have can a husband who entered into a subsequent marriage without following the procedure provided under the Muslim code be charged under RA 9262 or the anti-Bawsi law, in light of the Supreme Court decision in the case of Araza that marital infidelity is a form of psychological violence? Anyone po who can answer, but siguro pwede rin po si Attorney Abdul po yung dun sa considering the marriage.
Can you please, Attorney Banyes, can you please repeat the facts? A person who marries under what circumstances?
A husband who entered into a subsequent marriage without following the procedure provided by the Muslim code be charged under the provisions of RA 9260, the anti-Bawsi law, in light of the SC decision in the case of Araza that marital infidelity is a form of psychological violence.
Okay. That I think that presumes a lot. That presumes that once a marriage does not conform with Article 27 and Article 162 of the Presidential Decree number 1003, that automatically it will make things difficult, for either the first wife or the second wife. That's the presumption, actually, but it does not always happen that way. Actually, the requirements for compliance with Article 27 and Article 162, that one discussed by Attorney Ismail, this came about only in the Malaki case, as was explained by Attorney Ismail. Prior to that, the requirement was not actually stressed, but it was stressed in this ponencia by Justice Marvick Leonen. no case has yet been filed, no? Kasi bago pa lang yung Malaki case. So we don't really know how the court will approach it. But just to show you the basis of that provision on the so-called subsequent marriages, which is up to 4, the Quran actually allows that on the basis of being able to deal justly with the wives, no? Whether it is 2, 3, or 4, no? Being able to deal justly. And just treatment has been explained by Attorney Ismail by elucidating the example cited by Justice General Rasul and and Judge Rabani, no, Judge Rabani. But the Quran, states that, and we welcome that explanation by the good justice and Judge Rabani. However, it does not mention the exceptional case. Walang exceptional case na mention sa Quran eh. Although the jurists have brought that in because that is an additional ground. Now, second thing that you have to consider is it is only in the Philippines that these safeguards are put into the law. In other places, walang ganyang safeguard. In the past, before PD 1083, wala rin ganyang safeguards, no? So the marriages that came subsequent, the subsequent marriages rather that came after PD 1083 was effective, was made into law, did not take those requirements into consideration. Kaya nga sabi ni Atty. Ismail, there are actually many marriages who, in effect, violated those requirements in Article 27 and Article 162. We just don't know whether these marriages went through the courts. Because if it went through the courts, then it should have the imprimatur of the court. The understanding being, the premise being that the first wife or the earlier wives do not want to give their consent to the marriage, and that is why you have to file before the court, and the court will have to decide. But whether you go to the Islamic, you go strictly follow the Islamic teaching, which is being done in other countries, no? Parang hindi na kinakausap yung babae, they just go ahead as long as they treat the woman justly, no? This is what Islamic law is all about, no? And it has something to do with what I explained, yung totality of Islamic law. Meaning, if you sin today against your wife, the man's law may not be able to punish you, but God will punish you in the hereafter. So that sticks in the mind of a Muslim, in the back of a Muslim mind. Now, on the practical side, ito naman yung nangyayari usually, no? I'll give you a very very drastic example. If the man no longer loves his first wife, and that is the reason why he wants another wife, no? Or the first wife is no longer satisfying him, and it does not really matter whether this man is a Muslim or a non-Muslim, diba? But if he is a Muslim, he has the divorce. He can resort to divorce. If he divorces his first wife, then there's no first wife to get consent from anymore. Diba? He can just go ahead with the subsequent marriage. That can happen. That can happen because marriage, a divorce, is recognized under Islamic law. Diba? That can happen. But the truth is, it seldom happens. The Muslim males seldom divorce their first wife. They would rather do it diplomatically or just get a second wife, but without divorcing the first wife. No? But they could just do this. And this, I think, is the reason why the matter of requirements have not really been discussed that much. Kasi yung Muslim husband kasi has a resort to the institution of divorce, which Philippine law does not have. Diba? Philippine law does not have divorce. But the Philippines has a law on divorce. We lawyers, we usually say, and we hear people say that there is no divorce in the Philippines. That is wrong. That is wrong. There is divorce in the Philippines, but it is confined to Muslims, and it is under PD 1083.
Okay, thank you very much po, Professor Sadain. Unfortunately, we just really don't have enough time for now. We still have over 10 questions. Actually, some of them I noticed, no, as Attorney Abdul predicted, no, most of them are about marriage. I'd like to also inform everyone present that this is the first amongst what we see to be several webinar series about the Sharia, so that we really understand And maybe we can have those questions asked again. We'll take note of these questions, as well as I mentioned earlier po na maybe we can send the questions also to our speakers via email. The questions that were asked today, it ranges from the penalties up to marriage and to other specific concerns. It's really helpful, and it would go a long way, and maybe we'd be able to email the answers to our participants. In the meantime, because we don't have enough time po right now,
Yes.
again
Yes.
po, we'd like to thank you initially po for spending today to give us this sharing of information about the Sharia. So with that one, no, we would like to proceed to the presentation of certificates of participation to our resource speakers for today. So we have several certificates of participation po, actually tatlo po, and this would be presented to Professor Mehul K. Sadain, to Attorney Abdul Ismail, and to our Counselor at Law, Nazuddin Ali. This certificate of appreciation is presented to Professor Mehul K. Sadain for imparting valuable insights and expertise as resource speaker during the webinar conducted by the IBP-NCLA in collaboration with the Sharia Lawyers Council of the Philippines, the Bangsamoro Sharia Lawyers League of the Philippines, the Philippine Sharia Lawyers Inc., the Association of Lady Sharia Counselors at Law of the Philippines, and the Integrated Shari'ah Bar of the Philippines, entitled Understanding the Nuances of Shari'ah, given this 30th day of September 2022 via Zoom video conference, signed Attorney Bert M. Estrada, the IBP National President, and Attorney Eric C. De Ahar, the National Director for Legal Aid. The same certificate of appreciation is likewise given to Attorney Abdul Aziz A. Ismail, for again imparting his valuable insights and expertise as resource speaker in the same webinar, Understanding the Nuances of Sharia, given this 30th day of September 2022. Likewise, the same certificate is given to Professor Nazuddin A. Ali for also imparting valuable insights and expertise as resource speaker during the webinar entitled Understanding the Nuances of the Sharia. Again po, maraming salamat po sa inyong tatlo po sa ano. We look forward to hearing from you on other topics on the Sharia as we delve deeper into understanding Islamic laws. Your contributions are very much highly appreciated po. With that po, maybe we would, before we proceed to the closing remarks, if we would like to ask everyone to turn on their video cameras. Being this is the first webinar that we have on the Sharia, we'd like for posterity's sake po, for those who are still here po, to actually turn on their video camera so that we can just take several screenshots po that we would also like to share to our valued partners. So Adsi, magpa-assist na lang dito.
Okay po. So we have 3 windows po. I'll be beginning with the first window. 1, 2, 3. Wait lang po. Okay po. So for the second window, 1, 2, 3. Okay po. For the last window, 1. Sorry, may nag-log in pa po. Okay. 1, 2, 3.
Okay,
Thank you
very much, Adsi. Appreciate that. Now to proceed to give us the closing remarks on our first webinar on the Sharia, we'd like to call on our we'd like to call our NCLA Deputy Director, Attorney Dan Joseph Cruz, to provide us with closing remarks. Attorney Dan J.
Thank you, Attorney Jam. We once again thank our lecturers today, Commissioner Mehul Sadain, Attorney Abdulaziz Ismail, and Attorney Nasruddin Ali for giving us a glimpse of what Sharia is about and understand and appreciate the nuances of Islamic law. Truly, the Philippines is a diverse country, and we see it in our culture, heritage, governance, and even in the law. Amidst multiformity, which we embrace and respect, I believe it is safe to say that all of us identify ourselves as Filipinos, and everyone is crucial in our common mission to elevate the standards of the legal profession, to improve the administration of justice, and to enable the bar to discharge its public responsibility more effectively, which are the very missions of the Integrated Bar of the Philippines. Thank you everyone who participated in today's webinar. Enjoy the rest of the day and stay safe.
Thank you so much, Attorney
Thank you.
Dante. So
Thank
with
you,
that,
thank you.
these again, we repeat, this is just the first of a webinar series to help us understand the Sharia. Thank you to the NCLA Director, Eric C. Alahar, and of course, our NCLA Department Head, Adrian C. To our valued partners, again, the five Sharia Associations, the Sharia Lawyers Council of the Philippines, the Bangsamoro Sharia Lawyers League of the Philippines, the Integrated Shari'ah Bar of the Philippines, the Association of Lady Sharia Counselors at Law of the Philippines, and the Philippine Sharia Lawyers Inc. Thank you very much. I'm Attorney Jam Ibanez, IBP Director for Chapter Affairs. Thank you, as our Muslim brothers and sisters would say. Shukran. Please keep safe. Serve the country. Hail IBP.
Thank you also.
Thank you, Attorney.
Thank you very
you.
much.